At this point, I would like Mr. Miller here, but he'll be here shortly, as I understand it. In the meantime, I will turn it over to Commissioner Angetta, who was expecting to provide a summary and report back from the Legal Advisory Committee meeting from yesterday, March 17th.
Yeah. So let me just I'm basically doing sort of the report back, but let me just sort of summarize the work we've done as we're leading up to our discussion of the selection of the Voting Rights Act attorney. And that's pretty much all that the legal committee's been working on, so this is essentially our report back. As you know, the commission has been conducting a search for the VRA counsel. There was a request for information put out a couple of weeks ago, as well as a job announcement for a salary position that was put out. We received 9 applications for the applications in response to the request for information. We also received, I think, a small number of job applicants via the other vehicle. Staff made a determination that among those applicants, there simply wasn't anyone suitably qualified to make sort of a first cut. So we dealt primarily or exclusively with the 9 applications that came in via the RFI. We broke this up into 2 sets of discussions. We had an initial meeting on Tuesday where we, and all of us on the committee, as well as Commissioner Ward, because Commissioner Fickles-Weber was not able to attend on Tuesday, he was sort of subbing in, and primarily because of partisan affiliation, to make sure that the Republican Party was represented at the meeting. We did a number of things at that meeting. We narrowed the pool down, so we went from 9 applications down to 4, which we advanced to interview on Thursday. I think we were all pleased with the pool, at least, in terms of the overall pool. A really good set of applicants, fairly diverse. A number of large firms that have political or election law and constitutional law practices. At least one sort of specialty firm that focuses on political law and election law, as well as a couple of individual or small consulting practices where individuals who actually were former Justice Department attorneys were applying. And as we advanced we basically, and let me mention them. I've got my notes here somewhere. The 4 that we advanced were Federal Compliance Consulting, GRD Consulting, Gibson, Dunn and Crutcher, and Nielsen, Merksimer, Paranello, Gross, and Leone. I'll shorthand that as we go forward. 2 of those were sort of the former DOJ attorney applicants. Nielsen, Merksimer, again, more of a good-sized firm certainly, but more of a specialized practice. Gibson Dunn, a very large firm with a practice in, among other things, areas of election law and voting law. So I thought we all felt that was a good pool to advance forward for interviewing purposes. So and in addition to that, on Tuesday we also, in terms of looking at the budget and looking at the work that we would be expecting from the voting rights attorney, we did articulate a work plan, and I distributed copies at the last break, but they may have been lost in your pile of papers. I'm hoping they're there somewhere, but I put a little VRA in the right-hand corner. Hopefully that'll help you. And this is available to the public, and it's also online in the meeting handouts under CRC VRA legal budget. I'm not going to go through all of this, but basically what we tried to do was figure out, both in terms of actual work and how this might be budgeted. And we did ask the candidates to sort of, well, what do you think about this plan, and how are you going to spend the money, or how are you going to spend your time, and how does that reflect in terms of budget to go through each of these? And we did try to go through this in pretty good depth with each of the candidates that we interviewed on Thursday. So again, we advanced to 4. We advanced 4 candidates. 2 of them, who are California-based, were able to attend the meeting yesterday afternoon and early evening. 2 of them, Federal Compliance Consulting and GRD Consulting, who are based actually out on the East Coast. Both of them are actually in Maryland. We did by telephone. Obviously not the best in terms of interviewing settings, but we thought we had to just move forward and interview them by telephone. and I'll let what we're planning to do is sort of have each of the committee members as well as Commissioner Ward sort of present their individual preferences and have some discussion about them. So I'll leave that to each of us to sort of raise. But as we went through the four and had the initial discussion, there was pretty much an agreement that the two California firms were the ones we wanted to keep moving forward in the process. That there were a number of concerns that were raised about the capacity of some of the two smaller consulting firms and questions about subcontracting and the identity of subcontractors, for example. So I don't think we necessarily eliminated them, but again, I think we're feeling, as a group, we're feeling much more comfortable moving forward the remaining two. Now, ideally, what we wanted to present to you today was a consensus candidate who came under budget. We're not quite there, but I think we made a lot of progress, certainly. And I think there are probably two issues we want to certainly discuss, and one of them will be an action item, which is that at some point we would like a motion that we retain one of these firms. Well, I said at least one, I guess, but one or some combination, or some action regarding the hiring of the firm. The second, which I think might be a discussion, but there may be an action, is and Commissioner Galamas mentioned this earlier, there may be a need to augment the budget. And we didn't reach closure on that, and we tossed around a few figures, but I think we simply will bring it up for discussion. And if that's something the Commission wants to act on, we can do that. If there's a sentiment to change the budget, we'll just leave it at that. And I think that's it. And again, what ultimately, and we'll let the individual commissioners speak for a few minutes, which I think what the process that we want to follow is, the commissioners basically split 3-2 in terms of these particular firms. So 3 members, myself, Commissioner Blanco, and Commissioner Forbes, favored Gibson, Dunn, and Crutcher. And then Commissioners Focus, Weber, and Ward favored the Nielsen Merksimer firm. Okay, and we did try to, we went through some discussion trying to figure, can we reach a consensus on this? I think we ultimately said, well, I think we have significant differences here. Ultimately, this is an advisory committee. The full commission has to vote on it anyway. Let's simply advance these two. We'll have some discussion. And again, I think the procedure for now is to have each of the commissioners who were involved in the process to express, in just a couple minutes, express what I think would be the strengths and weaknesses, or simply state preferences and why they would want to move one or the other forward, and then open it for more questions and discussion. And I'm willing to take questions on the process as well.
Just one further follow-up, Mr. Anchetta, is if you could explain to the public, as they've been watching this procedure since Tuesday, just a little bit more as to where the Legal Advisory Committee did have a consensus, which was the determination of the other two individual firms that we interviewed. If you can just, because of the fact that they were former DOJ attorneys, and obviously giving the appearance of impartiality, could you explain to the full commission as to what consensus was reached by all of us on the legal advisory as to why we could not make a recommendation of those firms to the full commission?
And certainly other commissioners can add on to this. And let me preface this by saying, I think when and I and others were sort of thinking about this position, we were thinking, what would be a really good VRA counsel to have? What's sort of the ideal counsel? And I think we were sort of thinking, well, it might be good someone who had some work with the voting section of the Justice Department would be good. Someone who has both plaintiff and defense side experience. Can't always get that, obviously, because very often you're just typically representing one set of clients or the other. But again, ideally, maybe someone who had done plaintiff work, and then maybe perhaps had been working more recently. And this is our needs, working with a governmental body, say local governmental body, or state governmental body, an agency. But that's sort of, that might be a really good candidate. So then there are a lot of variations on that. So in looking at the two candidates who are former Justice Department attorneys, both of whom are, from what we could gather, were engaged in solo practices or consultancies, we had a number of concerns regarding capacity. What does it mean, given that you may either it may be new to this in terms of consulting on this type of work, or two, you already have a lot of clients that you're helping, and what role or how big of a task are you taking on? If you're going to take on the California responsibilities, would you be able to give us the attention we need? And I think all of us were feeling that and we're not feeling as strongly or as confident that the needs of the Commission would be best served through these particular candidates. Notwithstanding, and I should say this about all of the candidates, all that were not very, very highly sold, excellent reputations, all of them, very knowledgeable, and certainly the four we advanced, very knowledgeable, and quite a bit of experience in terms of litigation as well, particularly the Justice Department in terms of litigation and work reviewing submissions. So again, we all agree that we just, as much as that might have been ideal, it wasn't quite right for us, and we decided to move the other two forward. I think that sort of captures it, yeah.
Certainly, thank you. Commissioner Dye?
Yes, I was able to attend the Legal Advisory Committee meeting also on Tuesday and observe the committee. And one of the things that I requested at the time, and the Advisory Committee spent quite a bit of time discussing, is a matrix which was available to the public at the time, but it was an evaluation matrix to look at the time, 9 firms and part of the narrowing process. And I would just request that when we get to the point where each advisory committee member speaks about it, if you would actually speak to the matrix so that we can understand, kind of what, where you would rank one firm higher than the other, and just be a little...
And I apologize, I didn't distribute. Let me just highlight... I'm sorry. I apologize that I didn't distribute that, but I can highlight the basic criteria. And there's both a matrix form, which I think was posted, as well as a sort of an outline form. But the major things we were looking at included Voting Rights Act experience, including both Section 2 of the Voting Rights and Section 5, the different sections. Specific redistricting experience, because often VRA may not be tied to redistricting. Some experience working with public boards, commissions, clients similar to our commission. The ability and capacity to respond to various types of needs, including meetings that we're conducting, working with a consultant, certainly, and obviously working with a technical consultant will be a major part of the work, as well as working with community groups and the public. We looked at cost, and we did ask and we can mention them specifically as we discuss each one. We did ask them in the original application to indicate what, at least the hourly rates or not to exceed rates. As we'll discuss, I think, in our other topic, none of them came in significantly under budget. None of them would have gone quite a bit over budget. But we did ask them to, given this budget, what could you do for us? And we got some good data in terms of how that would work. And then we were also looking at general litigation experience and how well they've done, and do they win most of the time when they litigate. And then conflicts. And we did sort of include this as part of the matrix to remind the Commission we did adopt a policy that tries to parallels the Commissioner conflicts of interest provisions of the Voters First Act. It is, however, not as strict in terms of requiring in all cases that those criteria be applied to all staff and consultants. As you remember, there's some discretion built in. But certainly conflicts was a major consideration in reviewing the firm. So those are the big criteria that we went through.
Commissioner Dye.
Yeah, and I just wanted to expand a little bit on the conflicts. We got quite a bit of public comment at the meeting on Tuesday, and it kind of expanded that to, the only reason we're concerned about conflicts is concern about the ability of a particular candidate to engender public trust. So just wanted to provide that other way of looking at it.
Commissioner Raya?
I don't know if you've decided how you're going to present the opinions of each commissioner, but I think it would be helpful from my point of view to deal with one candidate and then the other, so that we can kind of keep do a little summary of your comments for our own notes. Is that, or do you prefer to do it otherwise?
Well, I think we're trying to avoid sort of a debate to that extent. It will end up being a debate, no doubt, if there are other disagreements among the commission in terms of one versus the other. But the recommendation was to move, as we were suggesting, we should have 2 to 3 minute summaries from each commissioner. We can change that, obviously, if the commission wants to. But that was our recommendation. Mr. Miller, if you wanted to add anything in at this point.
After a long evening and a very thorough discussion, it was the one consensus of the committee was that the best way to present here was for each committee member to simply summarize how he or she came out after that long debate. And I think that is a good format from which to have this discussion.
Okay, Commissioner Forbes.
Yes, I just wanted to follow up a little bit on Commissioner Dye's comment. To emphasize that the conflicts issue really was expanded to be a public ability to generate public trust. I mean, it really became more than just a mere conflicts issue.
Commissioner Blanco.
Yeah, for the public on the conflicts issue, just to reiterate, I know that we think everybody knows what we know, but there are new members perhaps in the audience. Where we have landed on the conflicts issue as a commission, after a lot of discussion, is that some of the conflicts that disqualified or were disqualifiers for commission members, after much discussion, we decided they would not be automatic disqualifiers for staff or consultants or experts that we would hire, and that there would be that even if they weren't automatic disqualifiers, we would look closely at some of the things that would have been disqualifiers. The more sensitive the position was that we were hiring for. So it was both a combination of trust and a combination of looking at some of the factors that were in the regulations and going through those and deciding whether they rose to the level that even though they weren't an automatic disqualifier, that people had concerns about.
Commissioner DeGiulio.
I just, before we had heard from individual committee members, I just had a point of clarification I was hoping to get. I thought in terms of those who are actually on the committee, who are registered committee members, it was Commissioner Blanco, Filkins-Weber, Aguirre, and Forbes. And I know that Commissioner Ward was there early on as I'm sorry, and Shedd, I'm sorry. Commissioner Ward was there early on in the process. I didn't know if he was officially reporting out, and I know Commissioner Galambos-Malloy was there as well. I didn't know if we were going to be hearing from them as part of the reporting out, or if it was simply the committee members.
And it's not we're not voting. I mean, we didn't have a vote out. I think it was appropriate for Commissioner Ward since he was part of the initial review process. And Commissioner Filkins-Weber did review them and conveyed to Commissioner Ward some of her preferences on the initial 9. Again, she wasn't able to attend on Tuesday. And I think, again, since we're an advisory, I thought it was simply for discussion purposes and trying to move applicants forward, we sort of went with those 5. Again, Commissioner Dye was at the Tuesday meeting. Commissioner Galambos-Malloy was at Thursday meeting.
Yesterday.
Yeah, which was Thursday. But didn't, instead of saying 3 versus 2, is not in that set of numbers.
Commissioner Ward.
Thank you. I just refer the commission back to a meeting, I believe it was last 2 weeks ago, and when this was being discussed, it was actually more than that. What the commission had said was that they felt because of the public light on this process and to help ensure transparency that they wanted equal numbers of Democrats, Republicans on that panel. So not only did I fill in for Commissioner Filkins-Weber, but at the time, Gil had offered his Republicanism, if you all recall, to sit on that panel and on that board. I had previously asked to do that, and between gentlemen's agreement, Gil gave me the nod to do it. So the way I understood it, it was more than that. And we did have Commissioner Dye there for the limiting process, and she was able to participate, so it was certainly open to everyone, and it was a great thing that was the case. But I also want to say that that aside, I guess the point is that I didn't want it to look like me being there was legitimate. Then I understood that I was there to balance out the process and make it appear clear, balanced, and fair, and I believe it was. I think we accomplished that, and that's to our credit. And then I'd like to say that the way we left it yesterday, I thought we were going to open up with a simple presentation. It seems like there's a lot of framing going on, and I don't know that conflicts of interest framing and things like that, and I just take objection to it because personally, I voted for us to apply the conflict of interest standards the way that we did for a reason. I was against it until I heard an argument that said, again, being a citizen, not experienced in this, that many of the experts we're going to need are in a specialized field, and that requires them to have worked with, there's two major parties, one of them or the other. And if we apply a strict reading to it, we might find ourselves in a position with no body who meets that requirement to provide expertise. That was the argument that was made back then that persuaded me, and that's why I chose to vote that we give ourselves the flexibility to apply conflicts of interest. I don't agree that the conflict of interest, the way I applied it in that meeting, was to expand that now to other things. It was simply conflict of interest was a pretty straightforward standard to me, and I would think that it would take a committee census to go ahead and start expanding upon that and making it larger than what it was agreed to be in the past.
I don't want this discussion to digress. I think we're all in agreement that Mr. Ward has participated this entire week, and we will certainly hear from him. And just on that last point, Commissioner Ward, I was not privy to this matrix, and as I understood it, we weren't placing any one of these categories higher than another. It's just it appears that Commissioner Dye would like to hear what the rest of the Legal Advisory Committee, where these firms fit within that matrix. So I appreciate that. Again, I don't want the conversation to digress, and I understand that some people may have had some comments, but let's just move forward. Commissioner Blanco, why don't you start this 2 to 3 minute summary of the two firms that we had proposed to recommend to this full commission, and we'll start the discussion in that manner.
I don't think that's how we were going to proceed. I think we were going to proceed with our views about, we weren't going to summarize, right? We were going to do whatever it's like we're preparing for a vote, basically. It's not a summary of the presentations. I thought that was what we had agreed upon.
I'm sorry, I understood that Mr. Miller, correct me if I'm wrong, that you had agreed that each member of the Legal Advisory Committee would provide a summary of their, of each of these firms. Yeah. And commence the discussion in that manner. I'm sorry.
I'll restate what I understood.
Okay.
Which,
process is everything.
Is not necessarily a shared view, but my understanding was that each commissioner would describe for the other commissioners why he or she came out in his or her personal deliberations the way he did.
Okay. That's my understanding.
I don't know if that's different than what anyone else has said, but that was my understanding. Is it would be a way of summarizing on an individual basis the totality of the evening's learnings, considerations, and debate, and reflect only a personal opinion as to that commissioner, and that we felt that was an expeditious way and an easy way to broadly inform the whole commission about what was taken in that evening and the divergence of views reflected after hearing the same information, following which the commission would be invited to inquire of any of the others about any subject relating to the firms. I hope that's a fair characterization of where the committee came out.
Yeah,
Perfect.
that's fine.
Perfect.
And I'm prepared to do that. So the two firms, Gibson Dunn, I'll tell you where I ended up, which was I felt very strongly that the concerns that I had raised and others have raised in public comment and that came out in the meeting about the fact that the I've got to get the complete name straight. The Nielsen, Merksimer, Paranello, Gross and Leone firm. I was in particular concerned that the firm itself is a registered lobbying firm, and I also had an initial concern about the work. The bid is for Ms. Leone herself and one other person at her firm to conduct the work, and I had some concerns about her having been a registered lobbyist within the last 10 years. I think that concern she described what the purpose of her lobbying was, which was to work with the State Board of Education, and I was not as concerned with that. But the fact that the firm is and has been a registered lobbying firm, for me, was something I could not overcome. As I expressed to the advisory committee yesterday, I think the firm is very qualified and knows both federal and state laws regards voting. I know that there were concerns raised by the public about having done mainly defense work and maybe some cases that had the impact of defended against claims that plaintiffs brought that were about increasing minority strength, but those were not, that was not the basis for my decision. I ended up saying I think they're a highly qualified firm, but that I did not believe that the sole product of this commission is the maps that we're going to produce and whether those maps are good, because we have good counsel and good expert consultants, line drawers, that the other product that this commission produces and is here to do is inspire public trust. And that if in one of our first important, and not to say the staff hires weren't important, but in one of the most watched and essential hires we're going to make, which is the voting rights attorney for this commission, that we hired a firm that is a registered lobbyist firm, and as many have indicated in their public comments, more closely affiliated with one party than another. I thought we will have lost half of our, we will have lost on doing part of our job, which is the public trust component of our job. We would have failed there. If we had discussed all the candidates at the Tuesday meeting, one of the candidates that didn't get very far was a candidate that had very strong ties to the Democratic Party as an attorney, and for that very reason I had not included in my list, and luckily nobody had else, and we didn't have to discuss him, but I would have raised the exact same concern because of what I think this commission has to do, which is engender trust, along with producing good maps. In terms of the Gibson, that's why I just, no matter what the qualifications for, that conflict for me was a deal killer. With the Gibson Dunn firm, I thought not only is it, I didn't move them forward because I thought they were the only one left. I was actually very impressed with their presentation. They presented a 4-person team for us. I thought it was an interesting presentation because the two partners that came and presented, one, Mr. Kolke, contributed language and dealt with the structure of Prop 11 and actually drafted Proposition 20. And I thought that could potentially contribute, if we ever come into a moment of having to engage in statutory construction, it would be very helpful to have the attorney who drafted one of those initiatives and help with the other as part of the team. He squarely addressed the issue that was raised about concerns about his bias, because there have been concerns raised about his membership as, I can't remember, it's in the State Republican Central Committee. There's two categories, and he's a member, but it's some kind of special associate member. But I think it really, he did address that it's associate, and that's limited. But he addressed that, but he also spent time explaining what his role was when he was tasked under Governor Wilson to work on the redistricting plan, that in his view he was brought on to, that his party supported the special master's plan that had ultimately been adopted, and that his work with the governor was part of that process of trying to create fair districts. At the time, it was a very contentious, bipartisan situation like we had in the last round. When we got to the question, the legal issues that we posed to them, I was very pleased with the knowledge of the field. We asked them what were the biggest challenges we would have legally facing the commission. Mr. Brown discussed particular areas in California where you're going to have two distinct minority groups with possibly majority minority districts, and those are going to be complicated areas, and that we're going to have to look at that when we ask them for challenges. We also went into long discussion about the Supreme Court cases, and both Mr. Brown and Mr. Kolke, pointed out to us sort of the fine lines between doing what's permissible to do in terms of drawing influence districts or crossover districts, but understanding that what the Supreme Court has said about what's permissible is not required, and also that it's important to keep other criteria in mind and show that you've included other criteria if you are also going to be looking at Section 2. So I thought that they demonstrated a very sophisticated knowledge of both constitutional law and voting rights law, and a lot of these challenges are constitutional as well as Voting Rights Act challenges. I felt that the response that we had asked them about what they viewed as what we should do with incarcerated, with prisoners, where those populations should be counted, was a very substantive answer. We asked questions about what the relevant population was in terms of Section 2, whether it should be citizen voting age population or voting age population. And Mr. Brown had a good description of the difference between it when just redistricting and CVAP when you're doing Section 2. And also, bottom line there is that I appreciated their perspective, which was that we are the client, and they repeated this several times. They are here to advise us. We are the client. We are the one, we need to understand the law, the data, et cetera. And ultimately, we're going to make the tough decisions. All they can do is advise us. And then I think there was, they did come in over our $150,000 budget that we had allocated, and that was something we should discuss. To get to the $150,000, to stop at $150,000 would not include writing the report that we need to submit with the maps. To do the report and assist the AG with the pre-clearance process. That would add additional hours. The total was 500 if we included the report and the work with the AG for pre-clearance, which comes out to 250,000. Their rate is a blended rate. They have different partners with billing different rates, and they would discount and blend the rates of the 4 persons on the team. I did have reservations about the membership in the Republican National, the Central Committee, California Central Committee, the Republican Party. I think the thing that put me sort of over the hump on that was Mr. Kolke having been an appellate judge in the state of California, and I felt that that gave me some confidence in his ability to be impartial and fair.
Commissioner Ward.
Can I request that the same disclosures that were made during the sub-panel be made to the full commission?
Oh,
certainly,
sure,
please.
Sure. So I mentioned both on Tuesday and yesterday that when I was the executive director of the Lawyers Committee for Civil Rights, Mr. Brown served on our board, and he also, on a pro bono basis, litigated cases with the voting rights attorneys in the firm. As executive director of the Lawyers Committee, I authorized all litigation and all settlements, and so I know Mr. Brown. I also should have mentioned, and I know I always get in trouble, that I know Mr. Mertzimer as well. He and I both serve very well on the board of the Public Policy Institute of California. I have a great deal of respect for him. I haven't worked with him. I've been on that board a few months. So those are the disclosures.
Commissioner Anchetta, do you have any?
Oh, I'm sorry. Oh, my turn.
Just disclosures.
I'm sorry. I thought Commissioner Ward was going next. Forgive me. Well, I'll incorporate by reference just about all that Commissioner Blanco said. Since
No, I'm sorry, just disclosures.
Oh,
we are going to go.
I'm sorry.
And only because we still technically have all 9 firms before us, even though we're only discussing the 2 that we're putting forward. And Commissioner Ward had asked, and I failed this morning in asking that this be done earlier. And so I'm asking, do you have any disclosures based on the voting rights attorneys who have submitted proposals for this commission's consideration?
Yeah, and if we're applying it to all, none to the 2 we're looking at today. Mine was only simply, I had been on a panel at a voting rights and election law conference with Gilda Daniels, who's the principal of GRD Consulting, and we know each other from that experience, and that's about it.
Okay, thank you.
Well, I didn't know we were doing the 9. No, I didn't. So Mr. Brad Phillips, who is a partner at Munger Toll, MTO, is also one of the firms that applied. They didn't make it to the final round, but I do know Mr. Phillips as well.
Anyone else? Okay. Do you have a disclosure, Commissioner Young? Please.
One of the firms that submitted a proposal to us was the Best and Creeder. They're the state's biggest municipal law firm. 2 of the partners were identified as part of the team that would provide services to us, Mr. John Brown and also Sonia Cavallo. I know Mr. John Brown through a number of tasks that he had performed for the city of Claremont. He was assigned to come in and address some of this unique cases that we experienced. And Sonia Cavallo was our city attorney, so I know her very well. I worked with her for 8 years in total. Thank you.
Any other disclosures? Commissioner Parvin.
As a former project manager for the MTA, I worked with representatives from Gibson Dunn, and they represented the MTA in a class action lawsuit brought about by the residents and merchants along Hollywood Boulevard. We had issues with that project, ground settlement, sinkhole, methane explosion, some other issues. They represented us, and they did a fine job, but I have not worked directly with Mr. Kolke or Mr. Brown directly.
Thank you. Anything further on disclosures? Commissioner Ward.
Yeah, again, just because it was raised in the sub-panel and it's out there in the public, just so that I think the whole commission should know, and I want to make it clear before, I think there's no problem here, but it was stated in the subcommittee, and that is that Commissioner Blanco invited Gibson Dunn to put in their proposal. It was a phone call that invited them to submit. It was just something that was stated, and I think that's a relevant piece of information.
Certainly, and again, I don't want to digress. In legal advisory, we had already asked permission of our chief counsel, Mr. Miller, that we would solicit, and obviously as part of almost our outreach for consultants to actually broaden our available pool. And so we certainly recognize that.
Again, nothing wrong with it. It's just it bears relevance to the discussion. And since it was mentioned in the subpanel, I just want to make sure the whole committee understood that was out there. But it's not. It's an accepted
practice
and appreciated a thing that was done.
Thank you, Commissioner Ward. Would you like to continue then?
Thank you. Like I said the other day, I'm not a lawyer, and I'm not going to play one on TV. I'll leave the legalese to the professionals. I'm concerned about the process. I feel strongly that, as I have from the beginning, that the procedures and the policies we do as a commission are merit-based. Proving the merit of the people we hire is what is going to create public trust. Doesn't it in your personal lives? Do you hire someone to work for you based on merit or based on appearances and perceptions? When you go for a job interview, does your resume highlight your relevant experience, knowledge of the job, and capability to do the job? Or does it highlight perceptions about you or what other members of your past job or current employment do? Or does it highlight you, your experience? I'm confident it highlights, again, your accomplishments and your experience in a given area. Why? Because that's what matters outside of this bubble. Perceptions are important, but perceptions change in the light of facts. Experience and proven track records don't become invisible to the majority of Californians just because some people state a perception of fear. Mr. Munger this morning stated that we're likely going to be challenged. No way around this. And he also said something I think is very interesting. He said that there will likely end up being 20 different ways to draw a map, all of which are equally valid. So just imagine 20 valid options to draw a line and 14 commissioners to each pick a different way. The experience and success of the firm we choose must have a proven track record of facilitating legal guidance to a commission with moving parts. There is not often a right or wrong in this, but a best option. And what we choose each time impacts communities. We are a first-time commission. Do we want a first-time Federal Voting Rights Act redistricting legal team? When you stack these proposals that we received on a scale of experience with the Federal Voting Rights Act, with litigating Federal Voting Rights Act issues, with the unique capabilities to provide mapping software, and a whole host of options to deal with the issues that we're going to face, we didn't even disagree at the subpanel that the scale is very highly weighted. The issue was appearance issues, what someone else does at a firm. But there was not a debate about the scale.
Weighted in favor of who? Sorry, just for clarification.
Leone, Mercer, Parnelli, Gross, and yeah. And also cost counted, and they came in at the cheaper cost. I know I seem passionate, but it's because this is the core of why I'm here. I don't want to be a part of a popularity contest. If I wanted to be part of a popularity contest, I'd go smoke in the boys' room and skip first period. But that's not what I want to do. I want to do things based on merit, and that's what's going to build the public trust. Public commentators got it right this morning. Qualifications and experience and the process counts. We as a committee agreed on guiding criteria. We agreed that we were looking for the most qualified a tested track record and the capacity to support the Commission's rigorous demands and timelines. But at the end of the night, it felt like deliberations had an appearance of being boiled down to a partisan play on both sides. And I have to admit, I don't understand it. Regardless of what the color of their webpage is, we all want the best. I believe that you want the best. And I know California wants the best. And despite my personal and exhaustive attempts to elicit a discussion last night on the merit of how Gibson and Dunn could be construed as the best choice between the two and federal voting rights experience, there was little. There was actually agreement, again, as I stated, that Nielsen-Merksimer was the most technically qualified. So why then? Why would this commission not choose them? They were good enough for Arizona's lauded redistricting commission. They were good enough for Florida. They've been good enough to work for both major political parties. It turns out one of them hired them a little more often. What would make them not good enough for us? Was the 30 years of Federal Voting Rights Act redistricting experience that this firm has successfully completed without challenge somehow solely because they worked for Republicans in the past? Because part of this huge law firm does lobbying? Prior to us commissioners, redistricting was a political process. And this firm is the premier redistricting firm. There's only two sides. You cannot get to the level of experience we need for this commission without experience with one side or the other. That is why I'm concerned when we collectively could consider being truly novel and ignore the clear merit. To err on the fluidity of perception. Commissioners, perception changes. A wise man once said it's in the eye of the beholder. But merit is a bedrock, and you have to ignore it completely to not select this firm to make a merit-based argument or make a merit-based argument against them. If public opinion is going to be won or lost on this one decision, if only one decision makes or breaks public perception of fairness, then we're doomed, peers. This is a false perspective. Public confidence is earned with a fair process that is transparent, inclusive, and breeds results. We have done everything in our power to meet the first two requirements. The third one, results, can be made or missed with the proper legal guise. This decision breeds results. It matters. Thanks.
Thank you, Commissioner Ward. Commissioner Anchetta?
So I apologize, I sort of jumped the gun earlier, but let me repeat, though. But since Commissioner Blanco, I think, summarized a lot of the pros and cons of each firm, and I have a few things to add, but I'll leave it to that to say that I really agree with much of what she said. I favored Gibson Dunn over the Nielsen-Merksimer firm. I think that both are fully qualified to do the work in terms of base qualifications to do the job. I should say that up front. Again, as I said, I would have loved to have had a former DOJ attorney do it. It didn't work out that way, but that would have been my preference, certainly. But given these two firms, I believe that Gibson Dunn presents a more balanced legal team. I think they have both plaintiff and defendant side experience, which is lacking, I think, in the Nielsen-Merksimer firm in terms of balance of different sides of litigation. I would certainly acknowledge that Nielsen-Merksimer has extensive experience over many years in this area, but I don't feel that Gibson Dunn is not qualified to do it. If you look at the state contracting manual, you will note that there are exceptions to the regular contracting process. One of them is for hiring lawyers and legal services, and I think there's a reason for that. We are certainly looking at the merits of these applicants. Again, this is why I'm incorporating Commissioner Blanco's statements. But when you hire a lawyer, you're hiring, there's often the phrase, you're hiring your best friend or a best friend. And I think you have to go with your gut in a lot of ways. Again, I'm not discounting all of the various criteria that I'm talking about. I think, again, I incorporate them by reference. But you have to sort of go with your gut. Who do I really want to go with? Because I have to trust them to really be my lawyer for the next several months. And I felt that Gibson Dunn earned my trust based on that. I think, again, the Nielsen-Merksimer firm is a highly qualified, very experienced firm, again, almost entirely defense in terms of this area. I would have, if they had more balance, I might have been more or less concerned about imbalance. Another highlight, again, I did have some concerns about potential conflicts with the Nielsen-Merksimer firm as a firm, not simply Ms. Leone, who would be the proposed lead. is a lobbying firm. So as a whole, I think that raises significant issues. A number of their clients, as I've reviewed the current list, includes counties that may in fact be advocating in front of this commission. Again, there may be very different areas of representation, but those are there as potential conflicts, even though Ms. Leone has indicated that she would try to have firewalls in place. I don't think that you can create enough firewalls when the entire firm is in fact a lobbying firm. So that was a strong concern of mine. I did have a concern, as Commissioner Blanco mentioned, regarding one of the members of the Gibson-Dunn team, Mr. Kolke. I'm satisfied after looking at the State Republican Party bylaws last night that his relationship with that party is pretty distant from the core of the Central Committee in terms of being an associate member. He was an associate justice on the Court of Appeals. He stood for a retention election. It's a nonpartisan office. I think all of the judges have to stand for retention, so to the extent he's an elected official, I had no problem with that. And again, I think, and this is not the only reason I'm saying I'm making this decision, but again, I think you have to go with sort of a gut approach as well, because when you're hiring a lawyer, you want to trust that lawyer, and I feel that I could go with Gibson-Dunn over the other firm.
Thank you, Commissioner Anchetta. Commissioner Forbes.
Yes, I too was supportive of Gibson-Dunn, and I would like to also incorporate what Commissioner Blanco said, with just the caveat that I thought that their presentation was very sophisticated. It was very knowledgeable of the law, and I could have listened to them for hours. That was so interesting. It was just a level of knowledge and understanding of the court cases, which is really very enjoyable, actually. The way I approach this is that, I was convinced that both firms can do the work. It is true that the Merximer firm has a longer list of cases, but I looked at those cases again last night after we adjourned, and most, not all, but most are relatively small, a water district here, a small school district there, and a lot of them dealt with, I think they're going to drawing districts from an at-large voting system. In other words, I didn't think that the experience was directly relevant to ours. Now, there were some that were, and I don't deny that. But I was convinced in my own mind that given the quality of the law firm of Gibson-Dunn, we are going to get, whichever firm we get, good legal advice that I believe will help us come up with maps that will withstand challenge. So that brings me to the second issue. We heard it enumerated here several times this morning. It's vital that this commission engender trust in what it does. We have two purposes. I understand drawing the maps that are considered fair is clearly one. But re-engaging the public, creating a process that the public has trust in is, I think, equally as important as the maps. And I think that it's a little bit like when you want a neutral broker, you want to have someone here who represents the Swiss. They just feel as if they're nonpartisan. And I think Gibson-Dunn does that. They feel much more nonpartisan. Yes, they have a Democrat, and yes, they have a Republican, but you did not get the sense that partisanship was what they were about. They don't have a history or don't have a reputation of representing one side or the other. Another thing I wanted to bring up was the lobbying issue, and I did have the same problem with Commissioner Blanco's characterization of it. I had a real hard time getting past it. I kept seeing in my mind's eye, well, let me step back one statement. In approving Prop 11 or Prop 20, the public wants things done differently. They don't want the same people running the show that have always run the show in Sacramento. So I had this image in my mind's eye if we were to pick Ms. Leone's firm. Commission hires a lobbying firm located across the street from the state capitol. This is not the headline I want to see happen. And I think that's what we're going to get back. And they talk about, and I appreciate this, Commissioner Ward, about how you engender trust by the product. But I think if you put what is perceived, maybe it's just a perception, a perceived partisan firm as your Voting Rights Act attorney, you will create a noise factor that I think will harm the process of coming up with the lines. Because the noise now will focus on who you hired, not on the process of drawing the lines. And so I think the fact that they're a lobbying firm, Ms. Leone may not be, she may not have been, the other participants may not have been, but I don't want to have to hire somebody who has firewalls. Maybe that's the way a standard thing is done, but in the public's mind, why you have to have any firewalls? And so I think the fact that they're a lobbying firm, to me, just creates, and have a reputation as a Republican firm. I'm sure they can do the work, but given the opportunity to have, as I said, the Swiss versus a perceived partisan firm, I have to go with the Swiss because they both will do the work.
Thank you, Commissioner Forbes. I'm also a member of the Legal Advisory Committee. I was not present on Tuesday for the narrowing of the list, but did provide my ranking. Was not familiar with the matrix, but I did the same, essentially, and did provide the list, and did participate yesterday in the interviews. I believe Commissioner Dye's suggestion that we take a look at this matrix and each of the firms is important because this commission as a whole put this matrix together and for a particular purpose. And in looking at both of these firms, it's my understanding, first of all, this matrix does not carry, and the matrix that I'm referring to is the one that Commissioner Anchetta put together, or outlined, summarized earlier today. As I understand it, there's not one item on this matrix that carries any greater weight than any other. And so in that regard, you're basically to look at these important factors and determine how high a particular firm would have in a ranking based on these factors. And I'm afraid overwhelmingly the Nielsen firm stands out far ahead of Gibson Dunn in each and one of these categories, and for the following reasons. The VRA experience for Section 2, Section 5, I'm assuming each commission member has reviewed this lengthy packet provided by each of the firms, and it's undeniable that the experience from Nielsen firm is there. Unfortunately, we have reference in the material submitted by Gibson Dunn as to only, I believe, 2 cases. And certainly they could have experience in more, but they didn't highlight it among their materials. And when you take a look at the 2 other young gentlemen who will likely be assigned to us the most, I'm afraid their background doesn't identify in their summaries not one reference to the Voters' Rights Act at all. In fact, both of them very qualified for where they're at in their career, absolutely exceptional, no doubt. But they are general commercial litigation associates. Another gentleman works in litigation, Department for Complex Litigation, Consumer Legal Remedies, focuses on securities and derivative legal litigation, consumer and wage and hour action. Now, these 2 associates would be certainly supervised by the other primary partner of Gibson Dunn, which is George Brown. Again, his focus, as I understand it, which we did discuss in advisory committee yesterday, has been primarily focused around the California Voting Rights Act and not necessarily entirely federal. And if I'm not mistaken, and I certainly can be corrected, I don't see any litigation involving redistricting except for maybe one matter with Mr. Coakley, but he does have a lot of redistricting involvement, so I do give him that credit. But when you're talking about actual VRA experience, I don't see it as much as exists with the Nielsen firm. Redistricting experience, unquestionably, I concur in everything that Commissioner Ward has said regarding the Nielsen firm's 30 years experience in that regard in comparison to the complete lack thereof that I see in Gibson Dunn. In regard to Commissioner Warb's contention that he thought that the experience of the Nielsen firm was not directly related, I draw your attention to the first qualification and selected non-litigation matters for which the Nielsen firm participated, which was with the State of Arizona Independent Redistricting Commission. It couldn't be more closely related as far as a statewide experience than what they have to offer to this commission for the entire state of California. If there's not more directly relevant experience, they haven't. And I don't see that comparable for the Gibson Dunn firm. The experience of working with public boards and commission, the laundry list is there with Nielsen firm. The Gibson firm, again, highly qualified on litigation matters. And again, conflicts exist as to each of these candidates. We've already recognized as a full commission that, and I've heard it said, and I will, it was Ms. Leone that said this, if you're going to attract competent counsel and actually a competent individual to serve our purposes, they are going to have deep-seated roots in this process of public law and likely deep-seated roots on one side or another. Unfortunately, as I stated earlier in my introductory remarks this morning, we did what we could to expand the pool of potential respondents to our invitation. And the pool that we got was limited. We had 9 firms and distinct differences in their capacities and their abilities to serve us. And we've now narrowed it down to 2. And both of them have been criticized, and both of them have supporting references. So this is why I had stated this morning that these decisions will be difficult to make. One final factor, cost. Unfortunately, maybe I misunderstood Commissioner Anchetta, but the Nielsen firm came within our budget, including, if I'm not mistaken, if I recall correctly, the report to the, I think it did include the report. There was additional costs maybe for coordination with the Secretary of State, but it included meetings, it included the training that we had requested, it included a lot, advising staff on the Section 5 submission, which, by the way, I don't see that Gibson Dunn has any Section 5 experience whatsoever as far as trying to assist in pre-clearance with the Department of Justice, which I believe the Nielsen firm has had. So, again, if we look at not one of these categories necessarily having greater weight than another, I find it troubling that any commission member can sit here with the difficult decisions that we have to make to state that anything would be a deal killer, quote unquote. There should be nothing that would be a deal killer. It's a compromise, and a necessary compromise, and taking a look at all of these factors, and not one of them should persuade us against that. If the conflict was going to be a deal killer, then this commission should have voted in the manner in which I had proposed, that we would strictly apply the statute based on an interpretation that I felt. But this commission decided not to do that. And I feel it's very disingenuous to now state that a conflict would be a deal killer when that was not the manner in which any of the commissioners that are using it now ever wished to use it previously. I do also believe in that regard on the concept with what Commissioner Ward's statement was, is that perceptions can change based on an understanding of facts. Firewalls exist, Commissioner Forbes, and for all the other commission members, as an appropriate manner and an acceptable legal manner by which a firm can protect their present clients' concerns and avoid conflicts of interest. And so they are an acceptable form of dealing with conflicts. And the manner in which Ms. Leone had presented how her firm would create the firewall, I find to be greater than I have ever seen suggested by a firm of her size. And I commend her on that regard, as I've never seen it. There's certainly lesser protections that could be taken and likely be accepted by the state bar for conflict purposes than what she is suggesting. And I find that incredible. Finally, one other distinct thing. There is a distinct difference between both of these firms in the manner in which they have presented their proposals to the advisory committee. There is a distinct difference. I was fascinated with Mr. Coakley's approach, by the way. Mr. Coakley's from Gibson Dunn. His approach for what he was recommending to this commission. In particular, and he wasn't committing necessarily to anything, but he had put together an idea that he basically would be providing advice on the law, providing choices to this commission, and bringing those ideas back to the commission, helping us understand demographics and district differences, and basically essentially giving this commission what we understand to be legal advice based on the issues that they can spot and provide us choices and options. And I certainly don't feel that there would be anything less than what we could expect from council. But the distinct difference that I find from the Nielsen firm, and I may have missed it in their initial proposal, and I apologize, but it certainly was clarified yesterday. They have Maptitude, and they have a technical expert who's also an attorney. And what I find fascinating is precisely what we need. When we direct our technical expert to draw the lines and the maps in this entire project that we're doing, I mean, charged with the duties that we give them, the Nielsen firm can offer us a situation where our technical consultant can turn over those electronic maps. And in so doing, Ms. Leone already has an identification of the areas based on the census data that's already come out of what is going to be of concern in the state of California. And she can actually use the expertise of her technical expert and look and see if it can comply with the Voting Rights Act. Review the maps, make recommendations to the extent in which there are any problems with whether we've reached the benchmark for Section 5, and whether we've reached the benchmark for Section 2, where those issues are, and how we can likely correct them and work with a technical expert. That is not at all contained among the proposal that was made by Gibson Dunn, and I don't know, nor do I have any confidence that they could help us with those recommendations. And again, on the final factor regarding cost, there is no compare. There's a $100,000 difference between the two firms for what was substantially the same thing, with the exception of the reporting. I just want to make sure I have that clear. Let's see. If I'm not mistaken, I think it did include the reporting. The separate additional cost would be additional full responsibility to follow with the DOJ from the Nielsen firm. But for everything that was offered, the $100,000 is significant, so I was pleased to see the quality and the substantive offer provided by the Nielsen firm for within our budget. One final comment, which I've seen from many of the public comments that have been made about the Nielsen firm, and the contention of conflicts or the contention of partisanship. In the materials that have been provided to us throughout all of the maps in the redistricting and voting rights laws for the last 30 years, according to Nielsen's presentation, not one of their maps has been challenged, and no Section 5 objection. That, to me, despite the contentions of partisanship, despite the contentions of them being a lobbying firm or whatnot, not one advocacy group in the state of California, as I understand it, as this being presented to me, has ever challenged the work that they had done. And what does that tell you? But that they have created fair and impartial maps throughout their redistricting experience, which can only lead one to believe that they have applied the law appropriately, fairly, and honestly. Thank you. I'll open it up for the rest of the commission. Have any questions for any other or any of the legal advisory committee? Commissioner Glons-Malloy.
Thank you. I was not able to participate in Tuesday's meeting. I was there late into the night with the legal committee yesterday, mainly as an observer, and I'd like to share my thoughts, which are fairly brief. We have received many number, I don't know the actual number, dozens of public comments regarding this particular decision that we have to make as a commission. We also received verbal public comments from many interested parties who did stay late into the night until after the interviews. When we initially discussed weeks ago how to interpret and apply the issues around conflict of interest, I was one of the people who thought we should retain flexibility, so we were actually able to look at the full pool, and once we had the pool in front of us, then make those tough calls that we were all selected to make. I do think now, having seen the pool, I do side on us needing to use the conflict of interest standard as a guide for hiring our consultants. And I'm saying this in the context of our VRA hire because that's the conversation we're having now. You'll likely hear me say it again tomorrow when we approach the line drawing consultants. So for me, as I've looked at the VRA applications, all along the way from the initial 9 down to the 4 that made it to the interviews to the 2 that we're discussing now, it's really been a process of elimination. And if I was to simplify and zoom right past the very deep legal and technical conversations we had with the interviewees yesterday, you know, for the commissioners, how can we in good conscience even consider hiring a partisan lobbying firm for the role of our VRA attorney? And we decided, and you know, I would feel differently if we had left on the table the option, and maybe that's something that folks want to consider, around having 2 partisan firms and having balance between the 2 major parties in California. And if there was a peer for the Nielsen firm, but that was bringing a Democratic perspective, that might be a team that I would feel comfortable considering in terms of outward appearance and public trust. But being that I come from the independent pool, I am a declined to state voter, and given the history of redistricting in California, quite frankly, I would say the same thing if that Democratic firm that Ms. Commissioner Blanco mentioned that was in the earlier pool, if they were one of the 2 that we were considering now, I would want to apply the same principle. Even though I think the implications are different for a libertarian firm or a Green Party firm, because we historically have had 2-party rule in California and across the country, in principle, I would suggest that we use the same standard. You know, after this is not the first time that I've had the opportunity to learn about the firm's work, the Nielsen firm's work. I think it's not an issue of qualifications. It is an issue of public trust and being able not to say it's either or, but do we have an option within the pool that allows us to balance both of those considerations? I think that's what we were brought here to the table to do, because many of the issues that will be facing us are not clearly one way or the other. You know, I'll end my comments again, just going back to how can we in good conscience consider hiring any partisan lobbying firm? I think that's an important question to echo here and for the public to hear. And I thought that it was very timely in our discussion. One of our public commenters late last night, he did bring to our attention a quote from the California Journal that is on Nielsen-Merksimer's webpage. And it says, "Nielsen-Merksimer has become a powerful force in state and national politics. It is safe to say that very little of any consequence occurs in state political and governmental circles without the knowledge or active involvement of the firm." So that quote to me encapsulates the history of California politics. Potentially it could be implied of redistricting. And much as Commissioner Forbes expressed, I'm interested in what can we do now in every step of this journey that we're on together to chart a different course. And there are many trade-offs in that. The Nielsen-Merksimer firm brings great expertise. I'm not denying that. But we will be in good hands with the Gibbs firm, and we will be able to avoid some of these other issues around conflict of interest. I left yesterday's interview feeling very strongly that there is no firewall big enough or wide enough to offset the conflict of interest issues that we would encounter and the public perception issues that we would encounter if we hired this firm.
Commissioner Ryan.
While you were talking, Commissioner Filkins-Weber, particularly about the firewall, and since some of us were not able to be at the advisory committee session, if you could describe to us how that was described to you and why you think it would be an effective barrier.
As I recall, there are two, possibly three, individual attorneys that would be segregated out. Also, what I found to be more particularly of concern is that each of the other attorneys would be signing a statement that they would not be involved in the redistricting or the representation of the redistricting commission. Additionally, the security, email, and
I have some fairly detailed notes on this. Each of the people brought on the case would be approved first by some combination of our legal counsel and or the full commission before they came onto the case. There would be a written policy signed by all lawyers in the firm that would establish the firewall. The firm would also establish a dedicated password-protected area where only the attorneys who are working on the matter could have access to the data, opinions, etc. The VRA offices would be secured so that nobody else could go in and review information. The emails are password protected, so other attorneys within the firm do not have access to each other's email accounts. And there was also the offer that where there were other elements of a firewall that had not been anticipated, that they were expressing a willingness to work through those.
certainly more complete than my notes, thank you. Any other questions or comments? Commissioner Ward? Commissioner DiGiulio.
I just had a couple questions or concerns that maybe the legal committee could clarify for me. And I appreciate the thoughtfulness of all the committee members in presenting their information. One of the additional issues that I haven't heard the committee talk about was in the Nielsen-Merksimer, one of the informations that they presented was they also represent a number of California counties at this time. So I saw, and this, I am not a legal person, but just understanding that some of those counties may or may not have issues with the commission or with what's happening. I'm not even sure exactly the extent to which the issues they're dealing with, but it occurred to me that there's another, I don't know if I'd say potential conflict, but there's an issue there for me if we hire a firm that's representing counties that may or may not be in conjunction or opposition to us. Again, the appearance as well as just the potential conflict that would put us in terms of a firm. So that was one question I had for the legal committee, if that was a point of discussion at all. And the second one is I'm again as someone who is another independent, as a declined estate. I am not someone who had participated in the legal discussion. I am more than comfortable, having read the information, watched as much as I could online of your first session, as well as hearing you reporting out, to be able to take the recommendations of the legal committee. But one thing I'm concerned about, and I have an issue with the Nielsen-Merksimer conflict for both those reasons. I think it would be very difficult for me to go down that path. But in terms of a Gibson-Dunn, $250,000 is what I heard you say, $100,000 over budget. I'd like to hear the legal committee's perspective. Is that something that's negotiable? Is that something that's reasonable? I know we have to have a discussion about the budget, but I'd like to hear the recommendations from the legal committee about whether that's a reasonable amount or if that's something that's option for negotiation.
If any, I took detailed notes on Gibson-Dunn, and then we'll get to Commissioner Blanco on the conflict issue. The way that the manner in which they presented it was that this was a substantial discount. They took a blend of their customary hourly rates and then just said that they would do it at $500 per hour, recognizing that the lead attorneys, Mr. Coakley and Mr. Brown, charge between $800 and $910 per hour. So substantial discount. And given that I'm recognizing it already as a substantial discount, I don't necessarily see that they would be in line for further negotiation. Essentially, they included for the $150,000 the training, just going off of the work plan, that training, one designated person for regular interaction, a checklist for the public, a work on geographic regions, and then doing the intense review with the technical experts, and then minimum attendance at 5 meetings, and you're already at $150,000. And that didn't include record development and the additional work with staff and the reports necessary for the Secretary of State and pre-clearance, which was another, just by themselves, another $100,000. So I did not get the impression whatsoever in the manner in which they presented to us that their $250,000 proposal was negotiable, but anybody else certainly can have a different impression.
I suppose the other question with that is from those who are lawyers, not being a lawyer, obviously being in the wrong field, but is that reasonable? Is that to be expected, I guess?
I'm sorry, is what to be expected?
Is that a reasonable price in the field?
No, it's pretty high. From my perspective, it's pretty high. Commissioner Blanco, and then Forbes, and then Chair.
Yeah, I'll start with the cost first, and then go to the issue of the counties. I think these are high rates, even the blended. I mean, they are, obviously, they're a large firm, and people are willing to pay them these rates. They must be going rates for some folks, but they are high. I don't think they're padded. I mean, I think it's a question of the rate. But I was very pleased that they went through the work plan and actually went, this will take this many hours, this will take this many hours. The only place where I saw, in terms of, there was room on, they allocated 175 hours to give advice, our regions that we would work on each of those regions and give advice on each of those regions, and they came up with a 175-hour figure for working. They're going to assign people to the different regions. They had a very methodical sort of work plan. There might be there might be could go up or down, but it's the rate and not the hours that are high, I think. I would hope that there could be some negotiation. I really do. As to the county, I'm glad you brought that up. We had, in Ms. Leone's presentation, she had a slide dedicated to addressing the concerns that had been raised Tuesday at the advisory committee meeting, and I guess also maybe partially based on the public comments that are posted. But she did not address the concern about the counties. And I am also concerned about that. She did mention that the other clients were smaller. They were water districts and these school boards, but we didn't get a discussion from them about the 4 counties that are...
In which counties were their clients?
Are, hold on, I've got them in the back. The appendix has them as Merced County, Monterey County, San Diego County, and Tulare, that those are clients for this redistricting cycle for the firm. But there was no discussion of that.
Just add, if you go to the Secretary of State's, the listing, whenever a firm is registered as a lobbyist, they have to list their clients. And I don't have that in front of me, but if you were to go to that, you would see the full list of clients they represent. And that would include, because I think the list that Commissioner Blanco is looking at is one in their application which focuses on the redistricting clients, as opposed to the counties they represent as lobbyists.
Yeah, these were redistricting clients.
Commissioner Forbes.
Yes. with regard to the cost, I'd invite Mr. Miller to comment on that as well, because he operates in that level of the legal. But the other thing,
Formally.
formally, the two other East Coast applicants did. One was not more than 200,000. The other was not more than 200,010. And so those were higher numbers, and that was an issue we brought up with them. But in their initial applications, the $200,000 figure was was on the table.
Commissioner Ward.
I think what this highlights is what I was cautioning of, what I'm afraid of. This commission, the way we're handling this, to me, seems like we're acting in fear. Seems like we're afraid to do what we were assigned to do, come up here and make the hard decisions in the light of what's best for all of California. And I say that because look at what we're talking about. We're talking about paying more for less because I don't like this perception. And I say perception. We can say that because there's a track record. There's a track record. We don't have to guess. They've done this. They've done this already. There's a track record, 30 years. The quote that was read from their website, again, I think that's painting us in a false box. I hear that quote, and that tells me that 30 years of being a premier California law firm means that they know what they're doing. And clearly, other states have felt so. Arizona, Florida, 30 years unchallenged maps. And we're sitting here deliberating, how can we pay more for less? It doesn't make sense. And if it doesn't make sense to me, it's not going to make sense to everybody watching. And that's why I caution us to have a merit-based debate. Help me understand, help California understand how on merit this firm is not the most qualified and not the best to assist, again, this first-time commission. And I'd also like to say a couple things about, I think my good friend Commissioner Forbes raised some good points, but I don't think they were completely a reflection of what the panel went through. As far as there being a choice between Switzerland and not Switzerland, that's not exactly accurate. There is a lot of public comment against Gibson and Dunn, and one of the panelists was against Gibson Dunn all the way up until the end last night, unless there was a firewall placed against Mr. Kolke. So this is not, we're not looking at Switzerland versus something else. This is two firms that, again, if you dabble in the business, you're going to be tied to one side or the other. One's done it for 30 years, and they've done it well. They've done it without challenge. They've advised boards like us. The other one hasn't. When we talk about running the show, we don't want to have the headline tomorrow saying, "Hey, folks, we run the show." We run the show. That's what's different. These guys are not going to be hired to go into a cave somewhere and secretly draw maps. That is what impressed me about this firm. If you look at their actual presentation, look at their handout, they had the most detailed plan for not just what they're going to do, but how the commission can elicit community support in this. They're the only one of the 4 people that interviewed that had a plan, an experienced plan, and how to go out, reach out to communities, and get buy-in. They've done it already. They plan that in, and into the price. Again, public's going to question all kinds of things. I mean, this is just the start. What's going to show Californians that we are looking out for them and that we are truly a nonpartisan group is how can we stand before them on the merit and justify the decisions we make. And if we want to make them out of fear or make something like this of a gut approach, I don't think that's what we've been sent here to do. I think we've been sent here to come together as a group and set our own personal things aside and evaluate that. And I'd like to also say that I know personally there's been some that we're digging in. I'm a Republican, and they've been tied to Republican firms or whatever the case may be. Like I said, I'm not a lawyer. I don't know any of these people, but I know that we have 2 VRA experienced people on the commission. They have, in the case of Mr. Anchetta, I was the leading advocate for him. The panel, as you recall, had voted and was moving a different way, but I championed Mr. Anchetta's selection largely for one reason: his merit. He brought more capability. He brought an experienced eye and background to the commission. And we all agreed that was more important than other perceptions or other things. And we've got it right. We've benefited from the VR experience on this panel. But that also, that experience comes with some ties. We're lucky. We're lucky enough to have 2 VRA lawyers on this commission. Do we not trust that they're being the vote makers, being the actual decision makers, are capable of ensuring a fair process with our VRA representation? I would challenge no. That's why I was so excited to have Mr. Anchetta join the team, because I trust that with that kind of experience, this commission can't fail. And so, again, stacking up the merit of it, considering the experience that we have, and looking at what is California really going to evaluate us by? Just one decision? Or by how fair our maps are? By how they impact the communities 5, 7, 10 years down the road? And they're not going to remember this debate, but they're going to remember what their districts look like. And clearly, this firm has the most experience to do that. And again, we're the vote makers. We can't operate out of fear. We have to own the process, and we have to do what we were sent here to do, and that is make merit-based decisions. Thank you.
Thank you, Commissioner Ward. Commissioner Anchetta. I'm sorry. Commissioner Aguirre, sorry.
I kind of look like Mr. Anchetta.
I was looking at you, too.
Let me just say that I happen to represent a community that is quickly becoming the majority in California. That's the minority community. And if we're talking about fear, I am afraid. And the reason that I am afraid is because when we look at the Voter Rights Act, it's specifically set to protect the interests of minorities, to not dilute their representation, to give them the chance to elect representatives of their choice. And I have a problem with a firm that works against that. So specifically, if we're talking about redistricting counties, as those counties that have been identified by the Department of Justice as having done things that were inappropriate, that worked against the interests of minorities, and then I have a problem with hiring that firm to represent us, being that seems to be contrary to what the VRA is trying to do and what we as a commission is trying to do. So I have a problem with that. In terms of sometimes you have to go from the gut, from this minority gut, it has to be that way. So between the 2 firms, not having any experience with the Gibson firm, looking at their application, comparing it to the Nielsen application, yes, I feel that both of them have some strengths, some weaknesses. I think that they can both do the job. The Nielsen firm, for me, the only connection that I have with the Nielsen firm was the time that we spent with Ms. Leone when she applied for the position of our general legal counsel. And at that time, when Ms. Leone presented to us her proposal and explained the intricacy of redistricting, we felt like, this was the girl, that this was the firm that could probably do it. However, when we talked about the registered lobbyist issue,
the fact that she was going to be unable to pull herself out of her commitments to the from her firm and pull out of those commitments and put all of that work on the other partners in the firm. When we talked about the fact that she was representing, as I recall, the county of Merced.
Well, again, you're not discussing anything that was in closed session. Council, I would like some clarification regarding whether or not discussions that were held in closed session would be permissible for us to discuss presently.
There's a different report out procedure for closed sessions, and it's simply a summary of not the transcript of what transpired, but the fact of what's transpired. I think it would be a better practice not to go into what occurred in detail in the closed session.
Thank you. Commissioner Geary, do you have anything to add based on advice of counsel?
Yes, I apologize for that. But the issue, getting back to the Voting Rights Act, as somebody who is representing a redistricting committee, I think would be contrary to what we're trying to do as a commission. And as a commission, we're here to make sure that we ensure that the Voting Rights Act, the letter of the law is followed and applied, and that would be my objective. Thank you.
Commissioner Galamas-Malloy. I had you up next. The discussions go on so long that you probably fall off. I'm sure I'm looking at the right list. Then I had Commissioner Dye. Okay.
Yes, I actually did one.
And then you. Okay.
So I have a couple of points. I think, being one of the many non-lawyers on this commission, that I trust that the legal beagles on our legal advisory committee, I'm satisfied that both of the candidates that we're looking at are qualified. But the reason I had asked each of the committee members to go through all of the different factors in the matrix is that we are looking at a number of different factors, and it's not simply experience. So in terms of, experience and understanding the law, it sounds like both firms gave a great presentation. So I'm not going to question that. I think that means a lot of those other factors start to weigh a lot more in my mind. There was a comment that, perceptions don't matter and perceptions can change. As a marketing professional, my motto is perception is reality. And I think that all of us volunteered to be on this commission because we would like to restore faith in the electoral process and in state government. And so I think perception is unfortunately a very important factor that we must consider. And I was one of the folks that voted to not apply the conflicts policy strictly at the beginning. And the reason was precisely as was stated before, that up until this first independent commission, this has always been a partisan process. So we were bound to have a small pool of qualified applicants who are going to be working on one side or the other. And I wanted to make sure we didn't restrict the pool before we started the selection. Given that a lot of work was done to get a good pool, I think that we do have the luxury of applying the conflicts policy at this point. I do think that, and I said this on Tuesday when we were just looking at paper applications, that, I was impressed by the fact that one firm clearly had tried to take a balanced approach. And I know that, some members of the public have still objected to one partner on the team, Mr. Kolke, but I stated on Tuesday, and I still believe this, I think the fact that he was very involved in the drafting of Prop 11 and was in fact the drafter of Prop 20, to me is very much a mitigating factor. I also, again, defer to my legal colleagues, the fact that his being an appellate judge means that he had to pass fairly strict peer review about his ability to be impartial. So I clearly think one firm has a more balanced approach. The other thing that I think a concern that was raised that is a concern to me, because I'm on the Finance and Advisory Committee, is our budget. And it sounds like we were not offered apples to apples number here on costs. And I would certainly hope that there's room for negotiations. It does not sound like they gave us a fixed cost. It sounds like they gave us an hourly rate. And so that there would be an opportunity to manage the scope. And I want to remind everyone that we have an in-house crack legal team between Mr. Miller and Ms. Johnson. And we hired them because they're, generalists, highly skilled generalists, with a lot of experience in managing outside counsel. So I would hope that between the two of them, that they would be able to work extremely effectively with outside counsel to manage and contain costs and ensure that we're getting the best value for our money. So I would not take any number thrown out at the beginning of a negotiation as our final cost. So that's all I have to say.
Thank you, Commissioner Dye. It has been some time, but the next in order was Commissioner DeGiulio.
I have a quick question for the committee as well, but maybe it's been addressed a little bit with Commissioner Dye, which was, I understand there's the individuals, maybe with Ms. Leone and Nielsen Merkstrom, and there was a discussion about her having a firewall, and that was being some of the issues with her. I'm also hearing to some extent that Mr. Coakley there may have been some issues with him, with Gibson Dunn, but maybe not, because does the committee feel as if there's not really the issues in terms of a need for a firewall, or was that presented yesterday? Was there any discussion in terms of, does the committee think there's any need to have Mr. Coakley remove himself a little bit, or is that because of his affiliation as a judge and the lesser role in the Republican Central Committee that Mr. Anchetta looked at? I'm just curious as to the need for Mr. Coakley.
My sense is by the end of the discussion last night, we did not feel a need to have any particular special structure for the Gibson Dunn firm, that the team as presented was the team that we would be supporting.
And so it was fully discussed. Next in order, Commissioner Ontai.
I don't know if this is appropriate, but if we could have, are both firms here in the audience?
Representatives from each, yes.
I would like to hear from each one, in a very brief manner, how you would describe your firewall.
Next in order is Commissioner Glamis-Malloy. We'll discuss that momentarily, Commissioner Ontai.
To go back to the budget numbers, my sense from having observed the interviews yesterday was that the $150,000 amount that was presented by the Nielsen firm, and I'm sorry, Commissioner Anchetta, I already gave you, I had the PowerPoint here. But there were some questions, and I think that the reason the budget issue came up on the committee was that the sense was that we might need more than what was included in the $150,000. So again, I don't think we're exactly comparing apples to apples if we look at 150 versus 200. The 150,000, we have a menu. I believe this PowerPoint is available. We certainly have a copy I can pass around, but it only actually included for our VRA council to be at 3 total commission meetings over the course of the coming months. Of course, there's the option, services at additional cost would include attending more meetings, additional written legal memoranda, et cetera, et cetera. So again, I think in both cases, the numbers are soft.
Thank you, Commissioner Yao.
This is a question for council. It's my understanding that we have to evaluate both contractors, potential contractors, based on what they have submitted to us. The discussion that we have had periodically about negotiating the rate and on, that really should not be part of our consideration. I'm hoping that whoever we select after the selection will better the the proposal rate, but to any discussion about lowering the rate and on, I don't think we can take that into consideration as part of our discussion. Is that? I'd like a reading on that, please.
The first thing I'd say is this is different than the next discussion we're going to have about the line drawers, where there are more strict rules, if you will, around the selection process. So you do have more latitude in your discussion here than in the next one, although we'll talk about the rules for the next one when we get there. It would be nice if there was a jury instruction we could read to you that says you're limited to the evidence that was presented in the trial, and you can't go out to the accident scene and make your own determination. The fact is, it's not that strict. I would suggest that it is useful, however, to follow something like that, because those are all the facts that we actually have, is what was presented to the committee and in the papers, so that your admonition is probably a useful one, that when we go outside of those presentations, we are speculating a bit. Now, without wishing to make a comment on either of the two firms that are present, I just think that it's useful. I believe it was Mr. Anchetta who made the reference to, or maybe it was Mr. Forbes, the proposed costs submitted by the Washington firms. Those firms have a fraction of the overhead of either of the two that are being considered here. And at the same time, their upper number was about $200,000. So I just think it's useful to have in mind the fact that we have an extraordinarily tight budget when we're thinking in terms of $150, and I use the other firms as a measure of that.
Thank you. Just in response to Commissioner Antai's suggestion, I would like to comment that the Legal Advisory Committee did discuss in detail whether we would have representatives from the firms come before this commission, and we felt that it was most efficient manner for us not to do that, because there was no necessity to reiterate everything that we had done yesterday in the legal advisory, and we certainly didn't want to waste the commission's time. So that was fully discussed, and the recommendation was that we would not ask for them to make any presentation today, given that we were not coming before you with a recommendation of only one firm, which we had agendized for presentation from proposed counsel if the legal committee could make a single recommendation. But since we could not do that, we felt it was fair for the commissioners' time, staff time, public time, and the firms themselves not to reiterate what we had put them through yesterday. So I'd like to hear from anybody else who has not commented, which would be Commissioner Baraba.
First, I found both arguments quite compelling. I can understand why you were there so late last night. The one issue that I think you raised, Commissioner Weber, was the two younger members of the firm from Gibson, Dunn & Crutcher, and I couldn't help but recall in 1980 we had had a stay on our ability to deliver the number to the president by an appellate judge, and that the evening before Justice Thurgood Marshall lifted the stay, and so we had a little party the next day in my office, and the senior members of the Justice Department legal staff, and this young kid walked, Levi's, and really fluffed up hair. And I said, who? And he said, well, he's the one in the appeal. And I said, I'm glad I found that out today. So it just seems to me that everything else that was said, it's what's making it so tough to make a decision on this one. But I don't think I would base that on whether there were some young people in the being represented, as long as they had some of the smart guys right behind them as well. Experience, I should say.
Certainly didn't suggest it on age at all. Given the hour, I do want to hear from. I think this is a very good discussion on the agenda. We have come up on 3 o'clock. We have been going some time since lunch, so I would like to consider a break. And so I may confer also with our executive director regarding the timing for the remaining portion of the agenda. But I would like to keep in mind that if we are getting close, I would like to entertain a motion and divert the conversation in that regard so we can get on to our other matters on the agenda. Commissioner Yao, is it brief before we take our break?
Yes.
Okay, please.
This is a procedural matter before us. In the event that we could not reach a majority decision, what is our likely next step? Because I think I would want to entertain that possibility and react accordingly.
This is a supermajority vote.
Absolutely.
So it will require 3 votes, just for the members of the public, and 3 votes from the Republicans, 3 votes from the Democrats, and 2 votes from the undeclared, as a reminder. I'm 3, excuse me,
yeah.
sorry. So I would defer to council as to what procedural recommendations, to the extent in which we did not make a vote, we would consider further deliberation and discussion over all of the candidates. I mean, although legal had made the recommendation of bringing these 2 forth, there's been no final determination, nor did advisory have any power to consider an actual vote. So every candidate whose material has been presented to you is still up for consideration. Council, do you have anything to add to that?
The statute does not give this to the California Supreme Court to decide. We would have to use our own discretion in terms of the most prudent path to move forward if the vote is not attained for one of the 2. So we're kind of back to the drawing board to figure out what our most prudent path is.
Okay.
Exactly, and so if Commissioner Dye could think about those options while we're on break, that'd be great. We'll take a 10-minute break, and on my watch, it's 3:07. We'll be back here at like 3:20 or 3:17. Okay, we're ready to reconvene. I'd like to just and the public, we're striving to keep in accordance with the timeline that we have presented in our agendas on the web. And I certainly recognize the importance of item number 5, which is the presentation from staff regarding the schedule and the methodology for evaluating the technical consultant proposals that we are going to do tomorrow. I do not want to delay that, but I have been delayed for 20 minutes. I'd like to continue this VRA discussion prior to 3:30. In the event that nothing is accomplished now in 3:30, and that the commission there is necessity for continued discussion, maybe a motion, I can't predict what's going to happen in the next 10 minutes, but I would postpone any further discussion on the VRA issue to allow staff an opportunity to make a presentation, because we also think it's very necessary. The public has advised us they want to know the methodology and provide them at least 12 plus hours to comment on the methodology before we get into this technical experts in the morning. So again, accommodating recommendations by the public. With any further discussion from possibly any commission members that haven't already spoken, Commissioner Montai, I don't believe is discussed in more detail other than asking a question. Otherwise, I'm sorry? Commissioner Robert talked a little bit. But if there's any other discussion, I don't know if Commissioner Parvenu. Okay. Commissioner Montai, anything further? No. Then I certainly feel this might be an opportune time to entertain any appropriate Commissioner Ward, did you have something you wanted to say?
Are you closing input, or?
Well, I don't. No, the floor is open for discussion. I mean, if nobody else has anything else to discuss, then I would.
I'd like to make one more comment then.
Oh, certainly, please.
Thank you, ma'am. I just want to say, I guess my point real clear. Okay. I don't really care who gets it. I don't care. What I care is the process that we use to do it. And that's what I've understood, what I've heard, and what I've listened to is a process that, again, leads to the end conclusion that we're trying to figure out how to pay more for less. And why is that? That's what I'm asking, why. I've heard from yesterday, I'm still trying to figure out why. How can we justify that? And the answer I get is fear. One of the commissioners stated that perception is reality. Well, that's the perception with this vote. If you vote on the merits and the facts of these two and the presentations that have been presented, you're voting, how can we spend more taxpayer money to get less? And the only explanation I'm still yet to hear is one commissioner used the word fear, the other used perceptions, and the other used lobbyist. And when it comes to fear, it was stated that they defended, against things. We're going to draw maps. There's likely going to be challenges to those. Guess what that means? Someone's going to have to defend our maps. That's what happens. Because someone chooses to take on that role of defending our maps, should that be held against them in future employment opportunities for future debate? Should that be a scowl against them? That's part of the process. And so if there's fear, or if there's a perceptual thing that is real that should preclude these people from getting it, I'd like to hear it, because I'd like to change my opinion. But my concern, again, and all this, is the process. And the other concern was that it was stated that she was the problem was her being a registered lobbyist. And the fact, as they were presented during presentation, is that she is not a registered lobbyist, that at one time she had the opportunity to represent 3 different families and 1 school board, and the state required her to anybody who wanted to represent them, which is what lawyers do, must register as a lobbyist. And as soon as those cases were done, the registration lapsed. I just don't want the perception to be that her career, or the person that's in question's career, was as a lobbyist. That's certainly different from what the facts are. And I think that that's what, again, the public is going to evaluate, is what are the facts against what's perception. And so in this case, I agree, perception is reality, and that's what we're going to be judged by. And if we make a vote based in fear and perceptions and things like that, we have to be able to explain it. And if we can't explain it in merit, and we can't explain it with something tangible, I offer that is far more damaging to this commission than either of these two options.
Thank you, Commissioner Ward. Commissioner Yao?
I think handed to us at the beginning of the day was a couple sheet of paper titled Bid Evaluation Guide. Oh, that's for the second one? That does not apply to. Okay. I just need that clarification.
Commissioner Raya?
Okay. It's my intention to make a motion, but there are a couple things I just wanted to proceed it with, if I may. One has to do with the whole issue of partisanship. Yes, it is. I'm sorry. I'll get closer. I have a problem with these big chairs. I know. Okay. We have received so many comments. In fact, probably since 8 o'clock this morning, I don't know, 50 or on not just this issue, but, it's very gratifying to know that the public is weighing in. On the other hand, from the beginning, reading comments that, address this one's a Republican, this one's a Democrat, back and forth. I think we also have to look at them in the same way that we look at ourselves. We acknowledge what our own biases or perceptions might be, and then we try to work around them. And so I try to do that, too, when I'm reading the comments that have come in. So saying that, I think in the end, I have to just say, what's my judgment in this case? I have a lot of confidence in the Legal Advisory Committee. I think you did a tremendous job of sifting through a lot of information, asking questions, analyzing, and I value everyone's opinion. But in the end, I guess I'm going to go with what I think is how I look at things when I'm hiring someone. And it's not just the resume, so I say, oh, this person has, many more accomplishments than the other. I look at the skill, I look at the potential, and I look at the trust issue and whether that person, who I think is going to fit best into the culture. So looking at the culture of the commission, we need to hire someone who I think obviously that the majority feel comfortable with and feel that we can just move forward and get this job done. So in that vein, I move the commission award the contract for voting rights to Ernie Gibson, Dunn, and Crutcher.
Any further discussion? Commissioner Galamas-Malloy.
So earlier I talked about my shift in thinking around conflict of interest, and I am overall in support of the motion that we're discussing now. I do have one concern in terms of just consistency, and that is regarding Mr. Kolke. My concern around him does not, of course, as with most of whom we're talking about today, is not around whether he's qualified, whether he brings relevant experience to the table, but around the fact that he was an elected official within the last 10 years and that he has been a member of his party in a leadership way, also in the last 10 years. And really, if we are essentially eliminating Nielsen and Merksamer from the pool on basis of real or perceived conflicts of interest, I think that we should consider putting a firewall or requesting that Gibson Dunn remove Mr. Kolke from work as our VRA attorney team.
At this point, I'm not certain that you can do that unless you're proposing a different motion. But the request and statement, the request for the bid and the statement for qualifications included Mr. Kolke, and what you're suggesting at this point is different than what was considered by the Legal Advisory Committee, which is different from the proposal that has been presented to this commission in total, and in reliance on the individuals that were identified as the team that would be working for this commission. So actually, if you're suggesting that as an option, then you can vote against this motion because that's essentially what you're suggesting. But any further comments or discussions, Commissioner Anchetta?
So I did ask that specifically of the representatives from the firm, and Mr. Kolke did say that he could be firewalled. That was not their preferred team, but he could be firewalled. So I think that if the motion is to go with the firm, maybe I could defer to Mr. Miller around the specifics of how the mechanics of firewalling, whether if it is sufficient to say that we would hire the firm, but upon retention we would say we would like one of your attorneys firewalled, if that's appropriate, or we need to sort of state that up front. I don't have a good sense either way, but maybe if there's some clarification that might be provided.
Well, if we become the client, I think that we have discretion to ask or advise the firm who's going to do work for the client. But at this point, I think the more important thing is clarity among the commission about what you're voting for. So it is sometimes our custom here to graft on to motions that don't always lead to the clarity that was the intention of the original mover. This might be an opportunity to vote in a, what I'll call a very straightforward way, and then in the event that doesn't succeed, look at other options.
Commissioner Ward.
Oh. Well, there goes Switzerland. Here's the problem. That that last round exactly proved my point. We set up an argument that we had equal representation by partisanship here, and we have a horribly tainted situation here. And we built that up, and we presented that, and then we say, and firewalls. Firewalls are horrible. Those things are scary, and the public can't accept them. And now that we've kind of pointed the wagons, now we're going to go ahead and say, wait a minute, perhaps we should instill some firewalls. That's my problem. That's been my point from the very start. This is not. This discussion is being based on things that you can't support, and the public is going to see this and see the way that we're making these decisions. This is the start. We got a lot more to make, and this is how we're gonna make these decisions. This is. It looks like partisanship. It looks like gamesmanship. And I'm serious. I don't care who wins it. I don't care. But I care about the process. And this is ugly to me.
I will also comment. I have stood doing so for some time. I'm absolutely astonished that there would be a suggestion that we put this to a firm and you firewall one person and yet you leave it up to the firm to have discretion to select the attorneys. We're here to discuss the individuals that have presented their statement of qualifications to us, and now there's a possibility that you want to firewall somebody, which you had feared firewalls in this entire discussion, and then leave it open to the firm to suggest somebody else, and we don't even know who that would be. That's absolutely incredible. I feel that the motion on the floor is maybe, again, I don't want to get into nuances either, so if the presenter could either consider withdrawing as phrased and consider rephrasing.
My motion was to award the contract to the firm. I have not accepted any amendment to my motion.
Okay.
And I never offered a formal amendment. We were in discussion mode, as I understood it.
Further discussion, Commissioner DeGiulio?
As I understand the motion, in the earlier question I'd had about Mr. Kolke as to whether or not the legal committee felt there was a need to have him firewalled, as I understood, that was not a recommendation, and I would accept that recommendation. So the motion that has been on the table is one that I feel is appropriate without the need for an amendment at this point.
Any further discussion? Yes, that's what we have right now. From any commission member.
I'm sorry, because we're sort of, for the first time, dealing with sort of real-time thing. I do have, there is an email that has been sent, which I or someone else can read during the public comment.
I haven't opened it up to public comment.
Right, but I want to, just for procedurally, I'm going to raise it during public comment, but since I'm the commissioner doing it during public comment, I want to be clear that that's what we're doing, as opposed to my just doing it now.
I understood it when you had explained it previously. We haven't gotten there yet. Any further discussion from any other commission member? Anyone who hasn't been heard from previously, Commissioner Ward? But anybody else? Then.
Well, I just want to express support for, I think we have a unique opportunity here. I think in the midst of all this long day and discussion, what we're missing is this opportunity with Gibson Dunn to actually have, if we could step back a little bit, like 5 steps, that we have the unique opportunity actually of having a firm that is highly qualified. I want to make the point that I think I made earlier, if not, that the experience that the firm has with the California Voting Rights Act is highly relevant. And I think maybe this was in, the meetings are kind of merging in my mind, but I pointed out, I think, in the Legal Advisory Committee that the California Voting Rights Act is modeled precisely after the Federal Voting Rights Act. When our requirements, the way I interpret the commission, the regs about our obligation to hire a Voting Rights Act attorney, there is no such thing per se. It's not like you don't walk around saying I'm a VRA attorney. What it means, though, is that you're familiar with the concept, the law, the philosophy, the application of the concepts that we have been discussing over the past several weeks. The maximizing majority-minority districts, racial polarization, how to prevent dilution. There are all those concepts are contained in the California Voting Rights Act. So if we have an attorney on a team that knows the California Voting Rights Act and has litigated those cases and worked with experts, witnesses, maps, etc., I feel we have a voting rights attorney. And I think that wasn't in the midst of the conversation about conflicts and all that. I don't know that we've explored that or stated that strongly enough, or that I have stated that strongly enough. And I think that with Mr. Kolke, I express that I don't have reservations. I know we're getting public comment. I think that we have here what we kind of, in a way, we're hoping that we have two people that perhaps bring a different perspective and may be identified in different ways, but we have them both on the same team with a very good firm. I don't think the 250, as has been mentioned, is outside of the solo practitioners were going to charge us 200. I think we should, and I know they're in the audience. I would really, if this ever went to them, I want you to negotiate with us on your price. And I just wanted to add those comments because I don't think we discussed some of those nuances well earlier.
Mm-hmm. Anything further from any commissioner before I open it up? Commissioner Parvati.
Prior to voting, I just want to add my comments here. I appreciate all the difficult and hard work that the Legal Advisory Committee has done to bring us this far. But I'm inclined to abstain my vote because for all the reasons that were mentioned earlier, I'm leaning in this direction, not out of fear, Commissioner Ward, but out of concern for all the reasons that were mentioned earlier. Mr. Kolke's still continuous strong ties with the Republican Party. I'm declined to state independent, so I'm not leaning in either direction in terms of Republican or Democratic nominees for this position. My two favorite, by the way, happen to have been eliminated from the selection process. But anyway, that being said, I'm very much concerned about perception, as was stated before, and I can't repeat all the points that were made about lobbyist connections and ties, but I have an overriding concern about that, and my gut feeling is telling me to abstain from this vote. Although I know Gibson Dunn is highly qualified, as well as Ms. Leone, my gut feeling tells me to hold back on this one because I can't, for the record, live with a clear conscience knowing that I voted and contributed to this particular perception.
Anything further from the Commission? One more, as long as you're not repeating everything, because I've heard everything that everybody said before except for Commissioner Parvati. Commissioner DiGiulio.
Just briefly, I think it's very important before we go to public comments that we make one last point, because I think this will come up probably tomorrow in the technical review, is that the public is very aware that we as a commission are the ones that are in charge, that regardless of who we get for the voting rights attorney or the technical consultant, as much as we can, we are trying to eliminate as much as possible any conflicts of interest. We are intelligent individuals. We are being able to be reflective on these proposals, and we can make our own independent decision, not in fear or anything else, but based on our own responsible, intelligent decisions, and that I hope the public has confidence in us as 14 individuals who will remain on task in terms of continuing that impartiality and the bipartisan, well, more than that because there's three of us, but the fairness that the public demands from us, and we take that task to heart, and we will continue that regardless of who's selected as our VRA attorney or technical consultant. I think it's very important the public knows that we keep that close at heart.
Thank you. Nothing very significant. I would like to open it up to public comment. In that regard, we are striving to be on top of the public's recommendations for this. And we do have the option at this point of having real-time public comments, which Commissioner Anchetta is going to present at this first opportune moment for public comment. I would like to, though, also reiterate our procedure of 3 to 5 minutes. And may I have a show of hands of the number of individuals in the audience who wish to 1, 2, 3, 4, 5, 6, 7, 8. We're beyond our limit of 6, so it is our practice in order for the efficiency of time and to also consider the concerns of the public. 3 minutes will be allotted for public comment. And Commissioner Anchetta?
I'll try to stick to 3 minutes.
Okay. So anyway, I would also like Ms. Sargis to keep track of the time and to advise members of the public when they have 1 minute and 30, and as well as 30 seconds, because 3 minutes is a short period of time.
Okay. So this is coming again. This is a new process for us. This is coming via email directly to the commissioners and to the voters first. So the normal posting is not occurring. This is not available, I think, at this point on the web because it's coming very close to the time we're actually speaking. So this is a letter presented by Eugene Lee of the Asian Pacific American Legal Center on behalf of the Legal Center, the National Association of Latino Elected and Appointed Officials Educational Fund, and the African American Redistricting Collaborative. I'm going to summarize as much as I can, but I do want to stress some of the highlights here. They write to inform the Commission that neither firm is qualified to serve as the Commission's VRA counsel based on information submitted to the Commission about the work. Although while they recognize neither firm meets the requirements set forth in the Act, the statutory provision of the Act, which provides the Commission shall require that at least one of the legal counsel hired by the Commission has demonstrated extensive experience and expertise in implementation and highlighted and enforcement of the Federal Voting Rights Act of 1965. The plain meaning of the section is clear. VRA counsel must have experience in both of those elements. They go on to say neither firm has sufficient experience here. They do believe that the two other candidates, Federal Compliance Consulting and GRD Consulting, given their experience in the Justice Department, do in fact satisfy the requirements of the Act. In the event that the Commission unwisely decides to ignore the plain meaning of the section and consider the two candidates recommended by the committee, they would ask us to apply the conflicts provision. Bolded, it would be a grave abuse of discretion for the Commission not to strictly apply all of the conflicts provisions to candidates for VRA counsel. The VRA counsel is central to the Act itself. The mandatory nature of the Voting Rights Act counsel is in fact important. They advise us, therefore, to apply the conflicts provision to candidates for VRA counsel means two things. One, that candidates as a firm are conflicted out cannot be considered for VRA counsel. This means that Nielsen Merksimer cannot serve as VRA counsel. Nielsen Merksimer is a registered lobbying firm as noted in the firm's application. 2,
1 minute left.
Okay. If a firm is not itself conflicted out, is selected as VRA counsel, then individual employees of the firm who are conflicted out cannot conduct any of the work that the firm provides for the Commission and must be firewalled. This means that if the Commission selects Gibson Dunn as VRA counsel, then Daniel Kolke cannot conduct any of the work that Gibson Dunn provides to the Commission. Mr. Kolke was elected to state office within the past 10 years and also was a member of the Party Central Committee, Republican Party Central Committee. I added Republican. Party Central Committee within the past 10 years, as noted in the firm's application. I'll be the last, near the end. We also know that the two other candidates whom the Legal Advisory Committee interviewed on March 17th have no conflicts on the provisions set forth in the code according to their applications. Basically, end of letter there.
Thank you, Commissioner Anchetta. This is a new process, and we're trying it out right now. And I think we do need to hold to the timeline. That's not to say that we're ignoring everything else that he might have skipped. This is going to be posted on the web with everything else. I'm sorry, did you?
I don't know. I'm just wondering what this is that we were asked to.
A member of the public provided that document and asked that it be distributed to the commissioners. It's just as if it were posted on the web. It should receive no extra weight. It's just that it came in this form.
And Mr. Miller, would you like it read now for the purpose?
No, I don't think that's appropriate. It was
it's just something we're supposed to consider right now in the opening of public comment on this agenda item.
You may read it at this time if you're able to do that.
Okay, thank you. But given the circumstances of time, we will...
I think it's fair to treat it as if it were posted on the web. I think that would be the best procedure, but it isn't.
Just one side comment. Obviously, this is the first time we're doing it, but I could imagine that any emails coming in, the volume would be significant, and we should address this through a process at some point after this agenda item is concluded.
Certainly, had you told me we had 10 or 15, that we might have picked a different process, but I thought we had it.
Right.
And we've completely disregarded my other schedule, but I do feel it's important that there are a number of people here to address this particular agenda item, and we will continue to go forward. First, a member of the public who wishes to address the Commission on the motion on the floor, particularly, which is the proposal to award a contract to Gibson, Dunn, and Crutcher. The microphone is open. I thought there were at least 6 people, 7 people. Please.
I want to go first.
Okay.
My name is Steve Kimball. I'm a partner at Stevens, O'Connell & Jacobs, a law firm here in Sacramento. I'm happy to support the application and the motion for Gibson, Dunn, and Crutcher to be awarded the position of VRA counsel to this commission. There has been some discussion about Mr. Kolke vis-a-vis conflict of interest and his impartiality. I was a staff attorney for Mr. Kolke for 3 years at the California Court of Appeal. I worked on dozens of cases with Mr. Kolke at that time when he was an associate justice, and he was incredibly impartial. Our approach when we were working on a case was to find out what the law said, and he was unbelievably diligent in that respect. We would get to the bottom of it no matter what. I remember the first case that I worked on with Justice Kolke was a case involving burglary law, and I was a civil lawyer at Gibson, Dunn, and Crutcher. I did not know California common law about burglary, but that case has now been cited something as a treatise on burglary law because we went so far and so deep in finding out what it meant and what the law was. And I can guarantee you, Gibson, Dunn, and Crutcher, with Mr. Kolke or without him, will give you that kind of service. They are, in this nation, one of the ultimate law firms as far as service, as far as knowledge, as far as expertise, as far as the depth and breadth of the work that you will get for them, and you get your money's worth when it comes to Gibson, Dunn, and Crutcher. They are not expensive, especially at the rate that I've heard here today, given what you're going to get out of them. And they staff their cases leanly, but thoroughly, so that everything is covered and there is no extra. I also wanted to advise the Commission that my partner, Chuck Stevens, who was formerly the U.S. Attorney for the Eastern District of California, would have liked to have been here to also support Gibson, Dunn, and Crutcher. Gibson, Dunn, and Crutcher he was also a partner. He was a partner with Dan Kolke back in the 80s and in the 90s until he became the U.S. Attorney. And in fact, they worked on redistricting issues together. And as he told me earlier today, he was incredibly impressed at the intelligence, at the integrity, at the unbelievable attention to detail that you get from Mr. Kolke. And I'll add my experience with Gibson, Dunn, and Crutcher, both when I worked there and when I saw briefs from them at the Court of Appeal, and when I've worked in conjunction with them afterwards.
Time.
Is to the same effect. So thank you very much.
Thank you, Mr. Kimball. Anyone else would like to address this Commission? Ms. Leone.
Thank you, Madam Chairman and members of the Commission, and I thank you all for your kind and thorough consideration of our application to be your voting rights attorney. I do want to address a couple of matters. First, I do believe we have unique qualifications and experience that would serve you well, and we would like to represent you. We do not represent either of the political parties, and any relationship we had as counsel to the Republican side ended years ago. We do not represent political candidates. We, as a firm, do not make political contributions. Being thoroughly involved in the public life of this state, our representation of clients does require, under the law, for us to register as lobbyists. We have presented to you, and hopefully that you would find thorough, a manner of walling off our attorneys who do lobby from the team that would represent you. And at any time, I would be pleased to go into those details. An issue has been raised about our representation of counties. We haven't been retained by them with regard to this process. If you are our client, we would not accept any such representation. An issue has been raised with regard to our capability to enforce the Federal Voting Rights Act and our representation of counties who are subject to the special provisions. The purpose of our representation is to ensure enforcement, and we do that adequately. We are the only counsel before you that has experience in filing and defending Section 5 submissions. We think both firms you have before you would do a good job. I think we would do better because we have hands-on experience. You've received a letter which calls into question my representations with regard to the Arizona Commission. Excuse me? 30 seconds. With regard to the Arizona Commission, I reiterate that we were counsel on the consulting team. We set up that process. An issue was raised with regard to our representations on the City of Hanford. The redistricting plan we created for that city was pre-cleared. I would hope you consider us on the merits, and thank you very much.
Thank you, Ms. Lonia. Any other member of the public that wishes to address this on the motion on the floor to consider Gibson, Dunn, and Crutcher?
Good afternoon, Commissioners. Joshua Golka, representing the California School Employees Association. Thank you once again for the time to come before you and provide our input on this important process. Despite the concerns that I raised at the advisory committee meeting last evening, we would support the motion to approve Gibson, Dunn, and Crutcher as voting rights counsel. And the reason for us is clear, given the choices that you have before you. There has been a lot of discussion today, and a lot of it has dealt with the track record. And so there's been some discussion about Nielsen Merksmer's lobbying clients and who they are and who they represent. And there's been some discussion about the Secretary of State's website. So I brought with me today a listing of Nielsen Merksmer's lobbying clients for this legislative session, 60-plus clients that include counties and others that you can read through. The firm, since the year 2000, has made over nearly $50 million and received nearly $50 million in lobbying payments from clients like the ones that are listed. On its own website, the San Diego Union Tribune has said that the firm's client list reads like a who's who of American industry. And there's been a lot of discussion today about perceptions and otherwise, but here you have a clear track record before you of a firm that clearly lobbies for clients and we think provides a clear conflict that a firewall isn't going to fix. And while Ms. Leone did state that their firm does not make political contributions, their clients, particularly their lobbying clients, most certainly do. And as I mentioned last night, we would be very concerned about, and their clients I'm sure are very concerned about the impact that redistricting will have on their business, not only in the state legislature, but before the Board of Equalization.
1 minute.
I'd also like to talk about two other issues. One deals with this issue of challenge and the bid submitted by Nielsen Merksmer is very clear that they state that the bid has not been successfully challenged in court. And they very clearly use those words. It doesn't say that they haven't been challenged. It doesn't say that they haven't beat some of those in court, but it very clearly focuses on the word successful and challenged in court. And there's been discussion about the time in Arizona
30 seconds.
where the Department of Justice refused to pre-clear Arizona's plans, and they had to be rewritten before they could be used. So they haven't come without challenge. They just haven't gotten all the way through the process before they were actually fixed. So we'd like you to keep that in mind. And they say they don't represent candidates for office, but they have and do represent sitting legislators. And so we would ask you to look closer into that if, for any reason, the proposal to move Gibson and Crutcher does not move forward. Thank you.
Thank you. Any other members of the public?
Good evening, ladies and gentlemen. David Saliveri again. I'd like to start out to say that I wish I could fully understand the process in front of me here. But honestly, for a lay member of the general public, it's probably just too complex and too much is going on much too quickly. I am very, very relieved this morning that you did disqualify the two candidates from the East Coast. And when I came in, like the gentleman to my right, I really didn't care between the other two law firms which you chose. Such was my relief about the folks on the East Coast. I thought that would have created a firestorm of public opinion that could possibly have destroyed this commission. Gibson versus Nielsen. In the morning, there was a suggestion that donors, philanthropists, etc., put money into the pot and help support the commission and its activities. I think that's a very bad idea for many reasons, which I don't have time to get into. But basically, I believe that would taint the process. Last night, at the meeting of the legal committee, it was put on the table $100,000 more added to the budget to pay for the higher cost of some of the other law firms besides Nielsen. I'd like to talk about perceptions for a second. The perception created by a $900 an hour fee is, in my world, pretty extreme. And even reducing that fee to $300, I mean, is already a huge amount of money. What kind of perception does that create? It creates a perception of arrogance, frankly. And I think that's something that you folks need to think about clearly and at greater depth. I would hope that the commission would stay on its budget target. That would create a very positive perception. Nielsen is $150,000.
1 minute.
And one of the reasons I think is quite possibly because they know what they're doing. They have a track record. They've been in this business for a while. And finally, when we're talking perceptions, we have to realize that there are many different perceptions in the state of California. And the conversation always seems to go to the perceptions of the left. And, guess what?
30 seconds.
There's a whole bunch of other perceptions out there, which I think that you should consider. Thank you.
Thank you, Mr. Saliveri. Any other member of the public? Mr. Walton. Thank you.
I'm Sam Walton, and I'm representing the NAACP. You've discussed this issue very thoroughly as far as we're concerned. So I'm here to simply enter our opinion, and we support the motion that's on the floor.
Thank you, Mr. Walton. Any other member of the public who wishes to address the commission on the motion?
Good afternoon. My name is Ruben. I'm the director of the California Voting Rights Institute at the Lawyers Committee for Civil Rights. I have, as a way of background, extensive experience in Section 2 of the Voting Rights Act, Section 5 of the Voting Rights Act, and have been involved in all 7 of the cases brought under the California Voting Rights Act.
Can you move the microphone closer? Thank you. If it's
I'd like to first just briefly comment on Nielsen Merksmer's bid. They are currently involved in representing the County of Merced in what is called a bailout procedure. I think that presents a direct conflict. I don't think that I would be an appropriate candidate for this position. I represent plaintiffs. I represent minority interests in trying to secure their voting rights. I don't think that Marguerite Leone is appropriate either for the same reason. She represents government interests. So with all due respect, Marguerite, I think that neither of us should be in the position of bidding for this position. Much has been raised about Gibson Dunn's lack of experience in the Voting Rights Act. That's just wrong on the facts. I've co-counseled with them on 3 cases now under the California Voting Rights Act. You can't successfully, as we have, litigate cases under the California Voting Rights Act without understanding the Federal Voting Rights Act. As Ms. Blanco pointed out, it is very much substantially patterned after the Federal Voting Rights Act, and you must understand Section 2. You have to understand the Shaw cases, the 14th Amendment redistricting cases, as they do. I can assure you that they are well equipped to handle the job at hand. The issue of Mr. Kolke has been raised as well. And all we would say about that is
1 minute.
If the Commission is concerned, Mr. Kolke, I'm sure that it can be addressed through some procedural manner. Firewalls are not unusual. I don't see anything inappropriate about them. I don't think that they raise any concerns. I think, if anything, they assure the public that the process will not be tainted, that anyone who conceivably could taint it is not going to be involved in the process. I think that the trust would be there, and I think that Gibson Dunn,
30 seconds.
Under those circumstances, would engender the trust of the public and be a worthy candidate for this bid. Thank you.
Thank you, Mr. Rubin. A member of the public who wishes to address this.
Chair, Commissioners, Rachel O'Brien on behalf of the California League of Conservation Voters. First, thank you for holding this hearing today. I'd be remiss, of course, if I didn't say that the environmental justice and incorporation of civil and voting rights acts are, in fact, very synergistic, and we're very happy to be a part of this process today. Also, we do understand that your selection of a qualified counsel is one of the key early decisions before you. Our request is simple. We don't want to weigh in on either of the candidates before you today, but we would like to ask that you select an experienced attorney, of course, who has the essential skill sets and absolute impartiality. Not to do so would impugn the legitimacy of this commission and, of course, weaken the process, which none of us wish to do. So thank you very much.
Thank you, Mr. O'Brien. Any other member of the public who wishes to address this commission on the motion? Seeing no one approaching. I'm sorry.
I have a disclosure.
Okay.
Well,
Well, we still have it open to public comment, and when I bring it back, then we can...
Whenever you want.
Okay.
I know that I've been asked to do that on occasion, so I want to disclose that Mr. Robert Rubin worked for me at the Lawyers Committee for Civil Rights, and he was voting rights attorney at the firm.
Okay.
I've known Mr. Rubin for about, I hate to say it, almost 20 years now, largely in the immigrant rights area, but haven't worked with him anytime recently, but I've known him for a long time.
Any other public comments? Okay, I'll bring it back to the full commission. Ms. will you read the motion on the floor for vote?
the motion is to award the VRA contract to Gibson, Dunn, and Crutcher.
And I'd like a roll call vote, please.
Commissioner Aguirre?
Yes.
Commissioner Anchetta?
Yes.
Commissioner Blanco?
Yes.
Commissioner Dye?
Yes.
Commissioner Raya?
Yes.
Commissioner DeGiulio?
Yes.
Commissioner Forbes?
Yes.
Commissioner Columbus-Malloy?
Yes.
Yes. Commissioner Parvenu?
Yes.
Commissioner Baraba?
Yes.
Commissioner Filkins-Weber?
No.
Commissioner Ontai? Commissioner Ward?
No.
Commissioner Yao?
No.
5 Democrats have voted yes. 4 declined to state have voted yes. 2 Republicans have voted yes. The motion fails.
Given the present agenda item for VRA Council and my promise to the public that we would address methodology, my suggestion, unless there's any objection, is that we resume discussion of this VRA Council after Mr. Claypool has an opportunity to present another significant item on the agenda that was promised to the members of the public at 3 o'clock, which was the schedule and methodology for evaluating the technical consultant proposals. Unless Mr. Miller has some suggestion otherwise.
I was going to say, would it be the Commission's intention to return to this agenda item today?
Yes, it is.
And if we could just, so the public is aware that the matter hasn't concluded for today's session, I think that's fine.
It hasn't. And what I would like to hope is that in this additional discussion regarding the methodology for evaluating our technical consultant, I have every reason to believe that much of the discussion that we've held today will also occur tomorrow in light of the technical consultants. And it's quite possible, in the spirit of compromise, that this discussion may aid the Commission to reconsider the manner in which they would like to address the VRA issues. So I would like to give the Commission an opportunity to hear this discussion, and it may very well aid them in consideration of a new motion on VRA. That still will be taken up today. It's just being momentarily postponed for the interest of the public to address this other agenda item. Thank you. Now I'd like to turn it over to Mr. Claypool on the subject on the agenda for the staff schedule and methodology for evaluating the technical consultant proposals.
If we could, Bill Rich, one of your staff, who is also instrumental in this presentation, is just handing out the guides, and then.
Okay, thank you.
So today, the Commission, besides myself, we have Marion Johnston. Marion Johnston, I apologize.
Hey, Washington.
And Bill Rich to assist me in giving this presentation. Bill was actually instrumental in the first draft of this, and Marion has seen it and has looked through it. And so most of what you see in front of you, and this has also been posted, I believe. This was posted yesterday. So that the public can follow along. Most of what you see in front of you comes from the state contracting manual when it comes to terms. And then the process is the process that we established through conversations with the Office of Legal Services as an appropriate process for this Commission to follow when they look at the invitations for bid tomorrow. To start with, the instructions require the Commissioners to complete an evaluation of the bids, and the term evaluation is used in the supplier selection process is a deliberative process which includes a price consideration. That price consideration, as you see, will be what establishes the order in which this Commission actually makes its review of the bids, and that will come in the latter part of this discussion. It's important that we understand the difference between responsive and responsible bidders. These two definitions are straight out of contract code. A responsive bid indicates compliance without material deviation from the requirements of the solicitation and the terms and conditions of the proposed contract. The first thing that any contract, as we'll get to coming up, the first thing any contract has to do is be responsive. You've sent out an invitation for your bidders to give you a proposal based on what you believe you require. In this particular case, what you require of your technical consultant for line drawing. Then, after we establish that the bidders are responsive, after you establish that, then we have to establish that they're responsible, that they possess the experience, the facilities, the reputation, the financial resources to perform the contract. So what your staff has done for you, in particular Marion and Raul Villanueva over the last 2 days, is they've gone through and checked for the elements in the bid that deal with responsiveness, the resume statements, the references, and the comments or the staff research related to conflicts of interest or partiality. The first thing that they looked at was responsiveness. Were all the items required by the terms of the ISB present in the bid that has been presented to the Commission? If an item is missing, your staff has noted the deviation and will present that documentation to the Commission for its determination as to whether the missing requirement is sufficiently material to warrant a failed score. Now, I've given you an example that someone would give you a cost statement that was contingent rather than stating a firm amount. This is an important fact. There are things that you require. We require signatures for specific documents. We need to go through and see that all those signatures are present. We require them to address each element of the bid. So they've gone through and made sure that each element was established to the best that they could as they reviewed the bid. That part of it will be presented to you in their review document tomorrow. The resume statements. Are the statements made on the resume truthful and accurate? If an item is questioned, the staff will note the statement and present documentation to the Commission for its determination as to whether the statement in question is sufficiently material to warrant a failed score. Again, an example. Someone says that they graduated from Chico State, and then we go to Chico State, and they didn't graduate from Chico. That's a material deviation. It may not seem consequential, but it is something that in its representation could cause you to question whether or not this is a person that you want to have work for you. References. Are the individuals referenced available to provide a statement regarding the bidder? Yes, sir.
On the errors, that would be an error of commission. How about errors of omission? Are they also identified?
Yes.
Thank you.
Are the individuals referenced available to provide a statement regarding the bidder? We put into our IFB that our bidders are responsible for making sure that their references were available over a two-day period. If someone wasn't available, we would have to report that to you. Again, this is a material deviation that the Commission is going to have to weigh in on as far as whether it matters to you when you're evaluating the document. If so, what reference does the individual provide? Did the individual providing the reference have firsthand knowledge of the individual or the things that they've represented in the bid? Finally, and this is the one that I think that will come to mean the most to you in this first step, comments or staff research related to conflicts of interest or partiality or disclosures made by the bidder or made against the bidder in public comment. We have a public comment period going till 1 o'clock tomorrow. There's been a lot said about everyone involved in both the processes that we're looking at. But we're saying if a comment has been made by a public commenter, that individual must state their name and confirm they have personal knowledge and or documentation to substantiate that allegation. That was the same criteria that was used for each of you. You may not know it, but the Bureau of State Audit spent countless hours tracking through the internet and everything else, and if anyone made an allegation, it had to be, somebody had to put a name to it, because that's an important fact. We don't have time or staff time to track every single allegation that might be made against the individuals bidding for us for either one of these positions, so we require that somebody step up and first of all say, I do have that first-hand knowledge, or I do have documentation. If we have received that, then we will investigate it to the best of our knowledge and report it to you. Just as important, our staff has gone through the internet to review the different bidders and the different people who have been on it to make a determination as to whether or not there has been an omission. And so if we found an omission, we will also report that to you in a document presented tomorrow. That document will post simultaneous with our presentation to this Commission of that document. So when we hand it to you, then we'll ask Christina Schuch to post it up on the site, on the website. So that's what staff's doing for you, and now here's what you're going to do for yourselves. There's going to be a two-step process. We're going to ask you to review those staff notes and any deviations noted to determine whether you individually believe that that deviation noted or any conflicts or statements of partiality are sufficiently material to warrant a failed score. If the bid is considered fail, and that consideration, and I should have put it in here, and I apologize, you would have to consider it amongst yourselves and make a determination. And I would presume, although Kirk, I'm going to ask this question, would that, as we look through the deviations, would that require, if they wanted to make that determination of a failed score, they would have to vote on it? Am I correct?
Yes.
And so you would have to vote on it, and then if it was considered failed, the bid is removed from any further consideration, and the bidder is determined to be unresponsive. Again, responsiveness is compliance without material deviation from what we asked them to present us. Second, if both of our...
Mr. Claypool, on that vote on unresponsiveness, is that a
Right.
supermajority vote as well?
Is it, or super? Kirk, we're going to...
Yes.
Or supermajority?
Well, these are, of course, issues something of first impression, but what occurs to me is this. If you're saying no, that's not quite the same as awarding a contract, which would certainly require the special majority. I think. Do you have a different view of that?
I think it's whatever they decide to do.
Pardon me?
I think it would be whatever the commission decides to do,
Yeah, I
whichever
think
vote
that's
they
why
need.
that would be my inclination, is when you're saying no to someone, that's not the same as retaining someone, where we know clearly that requires a special majority. I think the commission could all vote to make the determination rather than, I don't think I can instruct you must do it one way or the other, but I think it's not clear that as for the same reason, we can't saying a failed application necessarily requires the special majority.
So that would be like there were some people that did not make it through the process of the voting rights attorney finalists. In essence, we said no, and that did not require a supermajority. It's when we decided to hire them that we needed the supermajority. Is it a parallel kind of thinking?
In my thinking, that's a fair analogy, yes.
So, we're back to the matter that you're going to have to review these notes and make a determination as to whether any of the disclosures are made to you on a majority vote would be enough for you to say that this person has failed in being responsive to you. And again, always looking at what you have asked them to present you within that invitation for bid. So if you've asked them to provide you a page full of signed signatures, you should see the signed signatures. If you've asked them to present resumes, the resumes of all individuals should be in that document. If you've asked them to make statements of conflicts of interest and those statements have not been made, that would be an omission that would make them unresponsive. If we determine that both of the bidders are responsive, then we will go to step 2. The remaining bidders will be announced, and the sealed costs for the individuals or entities will be open and read to the public. At the same time, the staff will take an electronic version of the cost bids back to the office, because you're going to open them and those bids are going to be in there. And if we opened it and there was not an electronic copy of the bid in the package, it would be a material deviation that you would have to consider. Then we would take it, post it for public viewing. Okay, the next part. You start with the low bid. You're going to, again, I'm going to say this a couple of times, probably 3 or 4. It's important to remember that only the specifications written in the IFB may be used to determine a pass-fail score. The primary area of review, once we've opened the cost bid, is going to be whether the bidder's prior project experience is sufficient compared to the examples of population centers and ethnicities reflected in the IFB. You're going to have that opportunity to make those comparisons and decide as a commission whether or not the population seems similar to you, the ethnicities seem similar to you, because those were the 2 different demographics that we placed as a requirement for our bidders to give you a comparison for two projects. In the event that the lowest bid is approved by a special majority of the Commission, 3 votes each, Republican, Democrat, and not affiliated, as required by California Code Section 8253A5, no further votes will be taken, and the contract is awarded to that bidder. So we won't even look at the next one. If you look at the first one and you've gone through and you have already made it determined that they're responsive, and now you're going to say that they're responsible, and then you will take that majority vote and you will vote, and that's it. We're not going to move on. In the event that the lowest bid is not approved, the commission will be polled, and the commission members who voted no to determine the basis of each of their decisions not to approve the bidder will be recorded, and those responses will be the basis of the failed score. So if we don't come up with a supermajority for those individuals who said no, they don't meet the level that we believe that they should as a responsible and responsive bidder, we will poll you and get your information.
And the reason for that is in the event of a bid challenge that could be filed by not awarding it to the lowest bidder, that we need to have the reasons why that bidder was not responsive.
That will also speed our way if we determine that the information is clear-cut, that the decision is clear-cut. It will speed our way through any best if we choose to go to Department of General Services and say, please clear this protest out of our way, rather than to take an alternative route, because that is a possibility available to you. And then the Commission will then consider the next lowest priced bid until either a special majority approves one of the bids or votes are taken on all submissions without a special majority being achieved. In the event that no bids receive a special majority, the IFB will be canceled as provided in Section I and E of the IFB. So if we can't get a special majority for either one of the bidders tomorrow, we cancel the bid, and then we move to an alternative. Any questions?
Did you want to discuss those alternatives?
Certainly. The first alternative is to go to a non-competitive bid. If for any reason it were determined that we wanted for some reason to go to a non-competitive bid with one of the bidders that we've just reviewed, that would speed our way to possibly going through the Department of General Services process for a non-competitive bid. Non-competitive bids can take just as long as competitive bids, because you have to generally prove that there's only one person who can really provide this service, but we've already seen that we have two. That unless for some reason we make a determination that one of them doesn't have the skill set that we believe is needed to do the job, in which case we could go to the Department of General Services and say, this is the only one we've identified, and this is the only person we believe who can do the job for us. An equally compelling argument, but one that's used less frequently, is to say that this is business practice. We don't have time any longer to go through this process. We've gone through it. We're now at the end of our time period, and we need you to approve this non-competitive bid because we have to move forward. In that case, I think we will have a compelling argument just because of the situation that we're in. Third alternative is to go to an interagency agreement, and that would be with the only entity within state government that can provide this service that we know of, and that would be the University of Berkeley and their School of Law. That's the same School of Law that houses the statewide database, and we would rely on the University of Berkeley to provide the staff, to provide the line drawing services necessary to complete this process. We have discussed with the School of Law the possibility of an interagency agreement. We have sent them our IFB and said that in the event that we have a challenge to this process that we can't overcome, and the event that we cannot get a quick, non-competitive bid through the state, we would simply be compelled to use the interagency agreement with them. The interagency agreement, it cannot be challenged because it is an agreement between two state agencies to provide services between two state agencies. we would have to negotiate with the university over the terms and conditions of that contract and terms and conditions of the use of their employees. So those are the routes that are available to you. What we would like to see is just a good competitive decision or bid out of tomorrow and a good decision out of tomorrow. That's our fastest route. Any other questions?
Commissioner Yao.
In determining the pass-fail criteria of the decision, we absolutely determine whether someone passes or someone fails before we open the bid package. Is that correct?
You determine whether or not they have been responsive to you, and that's a very critical term. So right. Before you open that cost bid.
Right. You identify responsiveness, resume statements, reference, comment, or staff research related item. In other words, you can't open the package and saying I prefer the other guy and I changed my mind and he's that vendor is failed this criteria after the fact. Is that the way I understand the process?
Yes, you do not open the cost bids until you have made a determination that all bidders are responsive.
Okay. So the lowest bidder, after we open the bid package, the only way that we can go on and consider the second bidder is because of lack of adequate experience. Is that the way I read this paragraph on the yes, under the term responsible? In other words, the determination of whether that vendor has adequate experience or not, is that something we need to consider before we open the package, or is this something that we'll only consider after we open the bid package?
Yes. You have to make sure that they're both responsive and responsible, and at that point, then they have a pass score. If at any point they miss one of those, like the references don't pan out, then they have a failed score, and they do not compete in the cost opening.
So after you open...
With the one caveat that there be some deviations not material, and you may choose to overlook those.
But in this process,
I'm sorry, I'm still kind of picking up the other issue.
Right,
I'm sorry, I did not hear the question.
Okay. As we discussed with the Office of Legal Services, we won't consider the responsible part of the consideration until they've made a determination that they're responsive. Right. And then we'll open up the cost bid, and then they'll make the determination of responsible based on the projects. Is that how you understood the process we laid out with the Office of Legal Services, correct?
Yes.
Okay, so that's different than what Bill said, and that's because we wanted to give this commission, and General Services agreed that you needed to go through the process of determining responsive first, and then make that decision, and then you would have this opportunity to rank them by cost, and then check whether they're responsible by project. You could do the project first, if you wished, before you opened up the cost. But if you look at the projects before you look at the cost, and then you determine that all their projects are similar, when you open up the cost bid, you have no more options available to you, the lowest cost. So your only opportunity for a second discussion is by determining responsive first, and then whoever moves forward, you open up the cost bids. Now you can have the discussion on a responsible bidder.
All right, so we have to agree on the process of whether we discuss the responsible aspect. We not discuss the responsible criteria or the measurement or how we interpret that until after we open up the cost bid.
No. You will determine the responsive bidder before we open the cost bid. you will determine whether that bidder is responsible after you open the cost bid. And responsible will be determined by whether you compare their projects and believe that they have similar or comparable experience to what you've required them to have.
All right, let me just keep this discussion simple instead of talking about responsible being a broad category. Let me just pick one word out of this second paragraph on the first page: facilities. Okay. If somebody doesn't have a facility, doesn't have a computer, we can't disqualify them until after we open their bid.
No, you can, because they haven't been responsive in providing you a description of a facility that can match what you believe they need to do. They have to have all the pieces that you're requiring them to have. They have to have a way to access the database. They have to have a way to provide you with staff. They have to have a way to provide transportation for their staff. They have to have all those things in place for them to be responsive to your request. If they don't have any of those things, they're unresponsive, and we don't open their cost bid. Once we've determined that they are responsive, and I believe that the two groups that are in this bid will be able to show you that they have the facilities to provide you with the adequate facilities to provide you the services, then we're going to open that cost bid. Whoever has the lowest score, now you have to look at what projects they presented to you compared to the projects you asked them to compare against, and say, is that project comparable to this project? If you agree that for the first person who has the lowest score, that they are also responsible in their ability to provide you those services, then you have to award them the bid because they are responsible, responsive, and have the lowest score.
Yeah, if I could just simply ask you to read that definition out loud. A bidder is responsible, da-da-da.
A bidder is responsible if they possess the experience, facilities, reputation, financial resources, and are fully capable of performing the contract.
So if the discussion is on responsibility or responsible, and you specifically identify those things, does that mean that those things are not part of the responsiveness? Because I hear what you said, and I have trouble with what I read.
So in our bid, we asked them to provide facilities. If you read their bid and their facilities are not capable of, in your opinion, of providing, or they can't provide the facilities to secure the database while they do their line drawing, then you don't have to wait to say, is their facility comparable and responsible? You can say they haven't been responsive in providing you with the things that you've asked. But more importantly, your staff will have given you a review of all the things we've asked them to respond to, and you're only going to have to go through, unless you choose to go through the entire contract to review the staff work, which you can, but you're only going to be asked to look at those places where there's a material deviation and make that determination as to whether or not in that material deviation you believe they've been unresponsive. Then we'll go to part two.
I'm sorry. Commissioner Anchetta was...
I wanted to raise a question. Well, I brought it up in the technical committee, but I wanted to just get a little more clarity, and since we have Ms. Johnson here, it'd be good to have her chime in as well. I raised the question regarding whether a bidder gives you more than you ask for. In other words, it gives you some extra, let's say they have another subcontractor, let's say. Now, I don't think that's necessarily a material deviation, because they meet the basic stuff, right, but they give you some extra stuff, which, of course, make the cost higher. And I raised a question earlier whether and I suspect we can't do anything about that. That's just the way it goes. But is it the case that if that were, in fact, the case, it's some extra service, not a material deviation, and it is, in fact, responsive, we can't do anything about lowering the cost. The cost is what it is, period. Even though they have some nice extra thing going for them.
That is correct. You could ask for clarification of how they arrived at a particular cost.
Okay.
But if they included something and the other one didn't, you can't add to one or subtract to the other
Right.
to take
So
account.
as long as they comply with the responsiveness criterion.
Correct.
Right. Okay. Thank you.
I had Commissioner, okay. Any further questions?
I actually, because Commissioner Anchetta touched on a very important point, I'd like Marion to also explain tomorrow the process of what can be asked for and what can't be asked for.
And General Services is very specific about this. All you may ask for is clarification. If there is an omission, for example, in a proposal, you can't ask that that omission be corrected by supplying it tomorrow during the meeting. It had to be within the contract, the bid presented to you.
Could they ask for clarification on the omission?
You could ask for clarification on the omission. And you could decide that an omission is insignificant.
Are you suggesting that when we're asking for clarification, that somebody would be providing it in real time, or that we would be delaying an award for further clarification?
No, I think that you would be asking for it here. So let me go back to the signature on documents. Let's just say that there was a document that was supposed to be signed, and I didn't sign it. I missed it, and I didn't make that signature. That's a material deviation that you could determine, if you decided to, was significant enough to fail me in the process of being responsive. However, you could ask me, why didn't you sign that? And I could say, I missed it. I can't now sign it for you because that package is complete. But if my explanation to you is sufficient to you so that you believe that it's not material to the process, you could choose to say, that's not a material difference. We'll allow you to remain in the bidding process. That's all. So you can ask for clarifications, but you can't ask for additional items to be added into this document because it stands on its own.
Commissioner Glamis-Malloy and then Commissioner DiGiulio.
Ms. Johnston, can you provide a bit more guidance on this issue of material deviation and deciding whether something is materially significant or not?
Well, it's really a judgment call for you all, and what you consider an important part of the bid. The example of this is someone failed to sign the contract bid itself. I don't think that can be inadvertent. On the other hand, if someone failed to sign all the in-between parts of it and just overlooked one, you could decide that's not significant. Some others are more clear-cut of whether something is omitted. If they were asked to provide resumes and they failed to provide resumes, I don't think you could then say that that's adequate. You just say it's material deviation because how can you know what the people are they're planning to put on the project if they haven't given you their resumes?
Thank you.
Commissioner DiGiulio.
I just have a question about the process. So staff will give us their, I don't say recommendations, but their report on the responsiveness. So we will, just for simplification, let's say we have 10 recommendations on your part for issues of unresponsiveness for the issue. So
they won't be recommendations. They'll just be notified you that we have found a deviation.
So let's say we have a list of 10 deviations from both organizations to some degree. Will we then, as a commission, go through each deviation to discuss it and to see if, I'm just thinking, is there going to be a master list from which we will discuss deviations as a whole, or in which we could add to or of our own?
We will provide you with the master list. What you choose to do with it is your business.
Is that a point of discussion
or
for us today? I'm just assuming if we have to determine responsiveness and we have to determine whether it's a significant point, mode of deviation, we're going to have to go through each one individually to some extent. So I'm assuming someone will be keeping track of these.
Well, let me give you an example that I think some of you have noticed. The pages are supposed to be numbered. In one of the bids, the numbering is a bit confusing. That's up to you to decide whether you think that's a problem or not.
Commissioner Young.
So if we do proceed to open the bid, does that automatically assume that we, as a commission, consider, let's say, both vendors to be responsive
Any further questions of staff? Mr. Claypool, do you have anything further on this?
Yes, and I just want to touch on something that Marion said, because it's going to be very important for you to consider tomorrow. There are different levels of materiality. There are different things that you're going to have to draw a line on tomorrow, because this isn't something that staff can do for you, because we've been precluded by the transparency of the process, and so we've chosen this. We as a commission have chosen this path for you to make that decision on your own. Some of these items are going to, if some of the items would clearly be more important to you, I would think that anything that deals with an omission on confidentiality. But at that point, you're going to have to make a decision as to whether it was A, an intentional omission, or B, was it for one of the contractors and I just didn't know that this person did this thing 8 years ago. And then after you make that decision, then you're going to have to say, does it matter whether it was intentional or unintentional? We have our rules, and we're going to stick with them. So I would say that the things that you potentially could see when you look at this bid, some of them are going to be very clear-cut, and you're going to say that really doesn't matter in the great scheme of things. And some of them are going to be very clear-cut, and you're going to say that matters if you look at the potential for things that could be declared. So that's what you're going to have to grapple with, and at this point I can't tell you whether either has any material deviations. I can only tell you that will be what's given to you, and then that's what you have to do with it.
Thank you, Mr. Claypool. Any further questions of staff regarding this process and procedure, methodology, scheduling for tomorrow? Thank you very much. At this point, I'm sorry.
Oh, public.
Oh, okay. We would at this point open the mic to the members of the public who wish to comment on the proposed bid invitation guide that has been discussed by staff at this time. Are there any members of the public who wish to discuss this agenda item of the bid evaluation guide as been presented by staff? Ms. Schaefer.
Thank you, Madam Chairman, and to the Commission. I actually have a question. Several days ago, I'm not sure when, I found on the meeting handouts a longer document called Evaluation Team Procedures. And I don't know how to fit this into the discussion, and I thought it might help maybe the Commission also, but the public. Is this what your
that is the
report
form that
will
we
look
have been
like?
using, and we've gone through page by page and item by item, filled out whether they complied or didn't comply, or whether there was an omission, or...
Yeah, I see. Thank you.
Thank you, Ms. Schaefer. Any other members of the public who wish to discuss solely the bid evaluation guide?
Good afternoon, ladies and gentlemen. My name is Adam Abrams. I'm an attorney and resident of the city of Santa Monica, and the process in which the hard work you all are about to do is something that obviously, like many Californians, I'm interested in. According to the original experience standard as set forth in the draft and final invitation for bids, I have some concerns that there seems to be at least one of the bidders that should have been disqualified. The draft IFB was released to the public on February 22nd. In the relevant experience segment, the Commission asks that the bidder, quote, describe the experience of the firm in the past 10 years in performing no less than two and no more than 5 redistricting services for districts of a similar size, scope, and complexity of those found in California's most populous metropolitan areas. For example, Los Angeles, San Diego, San Francisco/Oakland, Sacramento/Roseville, Riverside/San Bernardino. When the formal IFB was issued on March 7th, this language was further refined by listing several large California metropolitan statistical areas, or MSAs, showing populations ranging up to 12.8 million people. To qualify, it was my understanding that the bidder had to show an experience redistricting an area of at least 1.5 million people. At the Commission hearing on February 23rd through 26th, no Commission commissioner, or member of the public objected to this experience standards. However, on March 9th, the final day to file an intent to bid, Commission staff issued an addendum lowering the experience standard from an MSA to simply an incorporated city, using it as example cities from the size of Los Angeles to the city of Riverside. There's an important difference. The MSC covers an entire urbanized region, often a full county or several counties. It will generally contain several million people. A city is an incorporated entity that rarely comprises a full urban area, and cities are often quite small. The city of Riverside, cited in the addendum, is smaller than a single assembly district, and California has 80 assembly districts. Tony Quinn, representing only himself, raised several issues with Commission staff. Were the Commission members aware of this change, and did they approve it? In a state of 37 million people, why was the standard lowered from a large urban area to a much smaller incorporated city? Did the addendum not discriminate against potential bidders who did not receive adequate notice of the change in the standard? Was the addendum invalid as it was issued on the deadline to submit an intent to bid? In response, Mr. Claypool responded, "We determined that our customer experience requirement might be too restrictive. We moved the criteria from metropolitan statistical areas to specific cities in order to expand the pool of potential bidders for this project." Further adding that no bidder questioned the use of the MSAs as the basis for the customer experience references, and no bidder was presented a question or a protest at the change to use cities instead of MSAs. If no one asked for the standard to be lowered, the question rises why it was done and who approved it and motivated it. It is my sincere concern that this commission operate as openly as possible, and that when we are asking for people to participate in this process, that the commissioners make the determinations on who's qualified, and that those be published in advance and people be held accountable to what was previously made public. I thank you for your time and consideration.
Thank you, Mr. Abrams. Any other member of the public who wishes to address the Commission on the bid evaluation guide discussed by staff? Seeing none, I'll bring it back to the Commission. Based on public comments, does anybody else have any final questions of staff regarding this evaluation? We're going to get there next, so we are going to take a break. I certainly appreciate the public's allowing us to deviate a little bit. We're trying to move through, and certainly appreciate everyone's interest in different aspects of our work. We'll take a 10-minute break, please. Thank you. Thank you. We are resuming the Citizens Redistricting Commission meeting for March 18th. Certainly, again, appreciate the public's patience in allowing us to maneuver the agenda just a little bit, and that we were off on time. But I certainly hope that you appreciate the full discussion and time that this commission has spent for these very significant decisions, such as action of our Voting Rights Act Council. So in that regard, I will return this commission to our discussion of the selection of the Voting Rights Act Council. In that regard, it has been brought to my attention that some certain information has come to light that may significantly change the manner in which this commission will address this issue. And in that regard, I would ask that Ms. Leone come before the commission.
Thank you, Chair Fulkins-Weber, and with the indulgence of the committee, I would like to once again thank you for considering the application of Nielsen Merksimer to be your Voting Rights Council. In the interest, though, of expediting your selection process, and with our best wishes for your success, we hereby withdraw our application. And thank you once again.
Thank you very much, Ms. Leone. At this time, based on advice of counsel, as we had discussed previously, pursuant to a question from Commissioner Yao, The floor is open for consideration of the other 8 remaining candidates for further discussion, clarification. I certainly would invite or entertain additional motion. I'll put them in order. Commissioner Ontai, Commissioner Yao, Commissioner Dye.
Given this information that we just heard, I would like for the Commission to reconsider the vote and have a vote taken over again on the current candidate.
Do I hear motion?
I'll second that motion.
Any further discussion on this motion?
Could we just restate the motion, just include their name?
Please, Commissioner Ontai, clarify so Ms. Sargis can take it down accurately before a proper vote.
The motion would be for the Commission to reconsider the last vote and take it over again on the same candidate that we voted for the last time.
That this Commission provide an award to Gibson, Dunn, and Crutcher as our voting rights counsel. Is there a second?
I'll second that, but let me suggest something. Let me suggest that we proceed with rescinding the vote, reconsideration of the previous vote, and then make a new motion to which was identical to the previous one, so that we don't combine two things, two totally separate things into a single motion.
So we'll take it in 2 parts. Then the motion is to rescind the last vote and to retake it.
But there's no necessity to do that when the motion failed. So this is a new motion. And it appears Commissioner Ontai has made the motion, seconded by Commissioner Yao. Any further discussion on the motion? Seeing none. We did discuss the same motion previously in open public comment, so I don't believe we would, Council, if you have any further, I think we can just move forward with a vote. But
I believe you can. There's no change from the time public comment was taken until now with respect to the identical motion.
Okay.
There's no change in the form of the motion. The consideration before the Commission is identical to as it was when public comment was previously taken.
But in the interest of our goal, I would...
there is nothing that would preclude you from taking additional public comment.
And I would like to do that. I will open the floor to further public comment on the change in circumstances and the new motion that's on the floor. Any members of the public who wish to address the Commission on this motion for consideration of an award to Gibson, Dunn, and Crutcher? Seeing none, I will bring it back to the full Commission and ask for a roll call vote, please, and rereading of the motion.
The motion is to reconsider the previous motion to award the VRA contract to Gibson, Dunn, and Crutcher.
Roll call, please. Unless Cal has some problem with the wording, but...
Well, Congress probably wouldn't say it that way, but I think it's good enough.
Roll call, please.
Commissioner Aguirre.
Yes.
Commissioner Anchetta.
Yes.
Commissioner Blanco.
Yes.
Commissioner Dye.
Yes.
Commissioner Raya.
Yes.
Commissioner DeGiulio.
Yes.
Commissioner Forbes.
Yes.
Commissioner Columbus Malloy.
Yes.
Commissioner Parvenu.
Yes.
Commissioner Baraba.
Yes.
Commissioner Filkins Weber.
Yes.
Commissioner Ontai.
Yes.
Commissioner Ward.
Yes.
Commissioner Yao.
Yes.
The vote is 5 Democrats yes, 4 declined to state yes, 5 Republican yes. The motion passes.
Thank you. Job well done, Commissioners. According to our agenda, we at this time customarily would...
Commissioner Weber?
I'm sorry?
It's a bit.
I'm just curious, were you going to, is there an opportunity for us to meet, for those who weren't on the, is there someone here from Gibson Dunn that could address, or that can at least see?
Oh, I'm
Yes, we have.
Yeah. We do.
Is it the young one?
No, it's one of the middle ones.
That's a subjective factor that we're not measuring.
Commissioner Weber?
Mr. Khan, is it
Would you
not?
like to come
Is that correct?
Mr.
Please
Khan, would you like to
approach
come
the
up?
Commission. I apologize
Commissioner
for...
Weber? Commissioner Weber?
Yes.
Before I could, is there something we could do or recognize to our appreciation to the other law firm for the action that they took? Yeah. That was, I thought, really quite special. And I don't know if there's something we could at least say something or do something.
Well, how about this? If you'd like, we could prepare a short resolution this evening and prepare it for the commission tomorrow morning, and you could adopt it at that time.
That'd be good.
That'd be great. Thank you, Mr. Miller. Mr. Khan.
Hello. I'd like to express my gratitude to all the commissioners for considering us for this extremely important and momentous opportunity.
I'm sorry, I don't mean can you state your name so that everybody knows who you are? The legal only had the opportunity to do it, and we definitely will be seeing a lot more of you.
Yes, no problem. My name is Matthew Kahn. I am an attorney with Gibson Dunn in San Francisco, and I am a California native, and I'm very excited to be here.
Thank you. Anything else you'd like to advise the Commission now that you have received this award?
No.
By full consensus?
Yes. Thank you for the vote of confidence. We look forward to getting to work right away. And I'd be happy to take any questions that the Commission might have.
Wonderful. Do any of the Commissioners have any questions?
Yes. I have a question, but I have a comment.
Wow. Everybody is chomping at the bit here. And we'll at least for another time. But Commissioner
A little young man out.
I never made reference to age. Not at all. Commissioner Dye, did you have anything?
Yes, I wonder if you could cut your rates in half.
I will certainly take that question up with the other members of my team.
Commissioner, no further?
It's already been.
Thank you very much and congratulations.
Thank you.
Oh, that's right. Okay. I forgot about that. Thank you. I think we're okay. I don't know if he's doing it or you're doing it. At this point, I would like to just briefly go over the agenda summary for tomorrow. Again, it's going to be relatively focused. Again, we will be commencing at 9 a.m. and it will be in this room again, room 447. A slight change, and for the members of the public, normally we customarily open up public hearing on non-agendized items. That will occur tomorrow, and based on the same procedures that we followed previously. But at this time, given the consideration of our invitation for bids, we're also going to be opening up right after that an opportunity for the public to comment on the actual proposals of the technical consultants. So in other words, there will be an open public comment on the agendized item before the Commission fully considers the technical consultants tomorrow morning. So if you are interested in providing any public comments specifically on the technical consultants whose information has been posted on the web, you will have that opportunity at reasonable time, barring no long public discussions on non-agendized items based on the time on here at 9:15. Then the Commission will consider the evaluation of the technical consultant proposals based on the evaluation guidelines of the bid that were discussed today. And that will continue on and takes up most of the entire day for Saturday. We did not agendize anything else for Saturday's discussion other than consideration of a vote, which will require a supermajority as well, and an award to the technical consultant if we may reach that, or a discussion of alternatives. And again, due to the fact that it is such a significant decision to be made by the Council, we have dedicated a full day to that. And so we will intend on doing that. And then again, opening up at approximately 5 p.m., excuse me, for public comment on non-agendized items. Any questions of the Commission regarding the agenda as it's proposed for tomorrow? And, I'm sorry, Ms. Sargis, did you have?
I just had an announcement. Since the Capitol doesn't open till 9 and the committee starts at 9, Chris Wagaman from the Speaker's office has graciously once again agreed to meet us out at the security area, the north entrance. If your name is on the special list, which is the commissioners' names and staff and our court reporter. We can get in at 8:30, and Ms. Wagman will escort us up to the room. If you miss that first escort, she will also be out there to escort a second group up a little bit later than that.
Okay, and the commission will certainly understand that, and I think there's one time, and certainly not when I was chair, that we started at 9 a.m., but we'll give due consideration to that and, for the members of the public to get up here in time. Any other questions about the agenda for tomorrow? Okay. Mr. Wilcox, I had charged Commissioner Blanco with providing us a summary of today's activities, and if I may, turn it over to Commissioner Blanco.
I'm not going to do this on a regular basis. And please, committee chairs, correct me if I'm wrong. I did this on the fly. So these are our action items that were for today, March 18th, 2011. In the area of public information, the Commission approved a web page design for the Commission, and we delegated authority to Commissioner Ward to create a tagline for our Commission. In the area of finances and administration, we hired our new budget officer, Deborah Davis, who will start immediately, and we also approved the creation of the hiring of one additional AGPA position in order to help the staff do its work now that the input hearing process has been brought in-house to be done by the Commission staff rather than externally. In the outreach area, we adopted in principle an April calendar for the first set of input meetings with the intent to increase as much as possible public access, both by meeting dates, times, and location. And we agreed to participate in an event in San Francisco, a redistricting event that is being put on by the Green Lining Institute. And in legal matters, the Commission voted to award the contract of voting rights attorney to the firm of Gibson Dunn.
And I did take it a little out of order. We do have one final agenda item, which is to open the hearing up to members of the public who wish to address this commission on items that are not on the agenda. And we're close in time. Okay. Seeing no members of the public who wish to address the commission on non-agendized items, may I have a motion to adjourn, or is there anything for... yes, Commissioner Ward.
Thank you, Chairman. I just wanted to go ahead and, because of the late hour, just extend all the option to give feedback on the tagline till noon, and at lunch I'll go ahead and take all that feedback and we'll have a final one. Is that acceptable to the Commission?
You're extending the deadline, which was 8 o'clock tonight, to noon.
8 a.m. in the morning, yeah.
Oh, 8 a.m. I'm sorry, what is it?
Yeah,
no.
I'd like to extend it tomorrow to have your feedback in.
Thank you. Any other final comments, questions, concerns?
One comment, just as a reminder, I will not be here tomorrow. I had put that on my calendar, so you all have a very critical vote to make, and I'm sure you'll make the right decision.